Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello. Happy Monday, everyone. Today's Monday, November 24th, 2025, but it feels like Friday, but it's Manic Monday. And so I don't really know why it feels like Friday, but to me, it feels like Friday. Does it feel like Friday to anybody else? I don't know. Maybe because we did a show last night. I don't know. It's weird. It's a short week. And so many people are not working Wednesday, Thursday, Friday. Many people are. Many people's kids are off from school all week. Some people's kids are off only Wednesday, Thursday, Friday. It's one of those weird weeks of a holiday. And here we are. Here we are on the tubes of you. Today is Monday, November 24th, 2025. As I said, Thanksgiving is Thursday, and KELSEY FITZSIMMONS will not be home for Thanksgiving. KELSEY FITZSIMMONS is sitting in Chicopee Women's Penitentiary or whatever the hell they call it there. And she has not seen her infant son since June 30th, 2025. And seems to me no end in sight to this absolutely horrific story coming out of Essex County, Massachusetts, because of course you're being masslit and gaslit. It's Massachusetts, after all, upside down, inside out Narnia of the United States as such, America, when it comes to all things legal. And I'm horrified by it. And I hope that you're horrified by it, because KELSEY FITZSIMMONS has not seen her baby. Once again, louder for those in the back. And her baby was born in February. So at the time she was separated from her infant, she was breastfeeding, and her son was maybe 4.5 months old. Right. And her infant son has not had his mother. Thank you, Maria. The reverse is also true. So it has been nearly 5 months of milestones and bonding and breastfeeding that KELSEY FITZSIMMONS and her son have had to go through. And I am sure that every day feels like a year. What do you think? Elaine, thank you so very much. It just reminds me to turn off my buzzer here. Thank you so very much, Elaine, with your super generous $100 Venmo. Elaine is so disgusted by this, and so am I. And we have yet to go over the Commonwealth's brief to the full SJC panel, which we are going to do today. It's 41 pages. We're not going to read it in its entirety because basically it is very repetitive of all the arguments they made before, except this time they really don't even address the Americans with Disabilities Act violation by the judge, which I happen to think is the strongest argument, Tim Bradel spent 5 pages on it in his brief, and the Commonwealth in their responsive brief maybe dedicates 1 sentence to the Americans with Disabilities Act, which is gross, horrifying. Pick an adjective. I don't know. And it's so interesting, isn't it? How during that horrific hearing that we listened to, because, you know, there was no camera in the courtroom and I had to order the FTR recording of that hearing on September 11th in front of Justice Kathleen McCarthy Nyman. You know, the one where she threw Kelsey back into jail because, you know, she was physically unable to breathe into the scram device without extensive pain for 4 hours afterwards. Because, you know, she was shot in the chest by a fellow officer and then airlifted to Massachusetts General Hospital, where she spent 53 days in the hospital and had many surgeries, including a collapsed lung with a chest tube, lacerated liver, couple of broken ribs, bullet fragments remaining in her chest. No big whoop, right? But because she couldn't breathe into the scram device without extensive pain, remember, she never said she couldn't do it. And Tim Bradel never said she couldn't do it. And the assistant chief of probation didn't say she couldn't do it. In fact, he wasn't going to violate her. Judge McCarthy Nyman decided, oh, you can't do it? It's torturous? Back to jail you go. And Kelsey was home for maybe 48 hours, did not get to see her baby while she was there. And now there's actually a stipulation between Kelsey and Justin, the baby's father, that Kelsey will not see the baby right now. That could change later, but it doesn't matter because she's in jail anyway. And despite the fact that Tim Bradel agreed that he did not want to file a reply brief, and he said to the SJC panel, he said, listen, I don't want to file a reply brief, so could you please just truncate the deadline here, and could you please just take a look? Could you take a look at these papers before Thanksgiving? You know, because the Commonwealth brief is due on the 20th. Could you just, you know, do us up a solid and maybe look at it on the 21st instead of waiting all the way until December 2nd or whatever the original date was? The SJC has decided, no, they're not going to do that. They're not going to start looking at it until December 3rd of 2025. And that was a motion to waive Rule 19 that was filed by Attorney Tim Bradel on November 13th, 2025, according to the docket, and November 18th, 2025. There's a little notation in the docket that says the appellant is not required to submit a reply brief. Further, the appellant requests this matter be submitted for the court's consideration and advanced to November 21st, 2025. That request is denied. The matter is to be submitted on December 3rd of 2025. So there's no chance that KELSEY FITZSIMMONS will be home for Thanksgiving, which, as we said here in the US, is this coming Thursday. It's not going to happen. And yet, let's take a look at the brief filed by the Commonwealth. What was so interesting was during the hearing, I think I digressed from this point that I was trying to make, on September 11th of 2025, the Commonwealth really stayed silent. They really didn't oppose anything that Tim Bradel had to say. They really took no position, except that they did think that Kelsey should be alcohol monitored. They did not stand up screaming and say, Your Honor, throw her back in jail. They did not say, we insist that she must breathe into that scram monitor. No, they were kind of cool. And it gave me a little bit of hope. Like maybe this DA's office in Essex County might have, I don't know, a little smidge of integrity and tell the judge, you know what, it's cool. Like whatever way you want to test her for alcohol monitoring is fine. As long as she has alcohol monitoring, let her go pee in a cup a couple times a week. Let somebody come to her house and let her pee in a cup if you don't want her to leave her house. And they've taken a completely different position on the appeal. So it's kind of interesting to me. And I don't like it. And Olivia says, if anything, the Commonwealth seems surprised by what unfolded in court that day. You mean surprised by what the judge did, or surprised by Bradel coming back 48 hours later and asking for, some more courtesies? And Mass Dad says, I saw it fly by here, but I don't know where it went. He said, sadly, I don't think the SJC will change the judge's action. And if they do, they're going to send it back to her. I don't know. I happen to think, my opinion is that the Americans with Disabilities Act is a strong argument. And I think there were less restrictive means to test her for alcohol. I think the court could have taken judicial notice of her injuries, especially since they arranged her in a hospital bed. The judge certainly knew what her injuries were. And I find all of the judge's ridiculous statements to ring hollow with me. They just do. Okay. At some point, a judge has to judge, right? A judge is supposed to be fair. And there are compassionate judges. There are so many compassionate judges. Then there are judges like Kathleen McCarthy Nyman, who also is going to be trying the case of John William Carey that's coming up in early February of 2026 with regard to the 1986 murder of Claire Gravel in Salem, Massachusetts. And John William Carey's defense is going to be that there were 2 police officers who might have taken the life of Claire Gravel who were never even investigated, one of whom was a Salem police officer by the name of Jerry Verrett. And any girls who were growing up in the 80s in Salem will tell you, because you've told me, I've gotten a lot of emails from you guys, everybody knew to stay away from Officer Jerry Verrett. And in fact, he eventually went to prison for the SA of a child. And then he's now deceased, but he was never investigated, even though in Claire's diary, she wrote in her diary that Jerry was after her, trying to get her to date him, and she didn't want to. And she flat left him in Major McLeish's on something like early June. And then she was murdered around June 30th. After a night at, again, Major McLeish's pub in Salem. So you can't make it up. You can't make it up. I think it's a good defense. So if you haven't watched that show, go back into my playlist and take a look, because I think it's going to be a very interesting case that we have chosen to follow. Moving on. This is the appellate briefs filed before the full panel of the Supreme Judicial Court in Massachusetts by the Commonwealth in the KELSEY FITZSIMMONS matter. And this is again on appeal from an order of the single justice of the Supreme Judicial Court. And this is the Commonwealth brief by Paul Tucker, who is the district attorney for the Eastern District, and who also is, very interestingly enough, somebody pointed out to me, remember we were just talking about Jerry Verrett, that Salem police officer who was never investigated for murdering Claire Gravel back in 1986. What did you guys tell me about Paul Tucker and Jerry Verrett? They worked together at Salem PD? You can't make this up, you guys. You just can't. The family roots of Massachusetts are deep. The tentacles go deep and they're twisted. They're so twisted. It's crazy. Table of contents, table of authorities, and the issue presented, according to the Commonwealth, is Judge McCarthy did not abuse her discretion or commit an error of law in finding the defendant dangerous and mandating conditions of release, where she appropriately considered the defendant's actions in pointing a loaded firearm at a fellow police officer and pulling the trigger, coupled with an admitted history of mental illness and persistent alcohol abuse. I'm just going to roll my eyes as we read through this statement of the case. Footnote 1. And footnote 1 just says what all the record references are to for the judge's convenience. And this is a 7-judge panel in Massachusetts. And I think they've waived oral argument, right? There's not going to be oral argument on this. Statement of the case. The defendant, KELSEY FITZSIMMONS, brings an appeal from a denial of her petition to a single justice pursuant to General Law 211, Section 3, appealing an order of the Superior Court finding her dangerous and detaining her prior to trial pursuant to 276-58A. The defendant was indicted on August 25th, 2025 for one count of assault with a dangerous weapon. Although there is no indication that the defendant was intoxicated when she pointed her gun at a fellow police officer who was at her home serving a restraining order, the Commonwealth demonstrated that alcohol fueled the precipitating violence in this case and has been a persistent issue for the defendant. Okay, first of all, I take complete issue with that sentence. Really? At what point did the Commonwealth demonstrate that alcohol fueled the precipitating violence in this case and has been a persistent issue for the defendant? Was I absent that day? Did I miss absolutely everything that the Commonwealth presented with regard to the KELSEY FITZSIMMONS matter? Because I don't remember that part. And I'm pretty sure that we went over just about every pleading in this case. Recognizing the dangers inherent in the intersection of alcohol abuse and mental health issues, this Superior Court Judge McCarthy, I wonder why they've sort of left out her hyphenated last name of Nyman, N-E-Y-M-A-N. Judge McCarthy fashioned reasonable terms of release, including the condition of submission to a scram device that would deter the defendant from consuming alcohol. Despite having obtained her release from custody within 48 hours, the defendant was back before the court reporting that she was unable to abide by the scram condition. Therefore, the court reasonably concluded that the only way to assure the safety of the community was to place the defendant in custody. This is a good time for one of the special emojis that members have access to. And it just says, how dare you? How dare you? How dare you now take the position that there was no other way to keep the community safe? And how dare you now take the position that how dare she come back to court 48 hours after being released? How dare she bother the judge with her silly argument that it was painful for her after being shot in the chest to breathe into that scram device for extended periods of time? How dare she? Procedural history. A complaint issued on July 3rd, 2025, charging the defendant with assault with intent to murder and 2 counts of assault with a dangerous weapon. The defendant was arraigned on August 7th, 2025, again from a hospital bed, and after a hearing was ordered held pursuant to 276-58A. The defendant appealed the determination of dangerousness to the Superior Court, and on August 14th of 2025, the court, Judge McCarthy Nyman again, conducted an evidentiary hearing. One day later, Judge McCarthy issued a decision upholding the finding of dangerousness and the conclusion that there were no conditions of release that could safely permit the defendant's release, period. Notably, the court found that it, quote, has not been presented with a satisfactory release plan. On August 18th of 2025, the defendant filed a renewed Superior Court bail appeal with comprehensive release plan for reconsideration, which the court denied on August 25th of 2025. That same day, the defendant was indicted for assault with a dangerous weapon. And then in parens is a very important sentence. The grand jury, having returned a no bill on the proposed indictment charging armed assault with intent to murder. Okay. What does that mean? Well, Judge Saul Wackler, who was famously the Chief Justice of the highest court in the state of New York, famously once said, a good prosecutor can get a grand jury to indict a ham sandwich. Well, the grand jury in Essex County did not indict the ham sandwich of KELSEY FITZSIMMONS for attempted murder because they apparently didn't believe the witnesses who testified in front of the grand jury, which I'm going to assume, since grand juries are secret, was Officer Noonan, the guy who was actually shot. I mean, the guy who actually shot KELSEY. So the grand jury not returning a true bill indictment on the attempted murder says a lot about the weakness of the Commonwealth's case. The defendant was arraigned and the Commonwealth filed another motion for detention pursuant to 276-58A. The court, McCarthy Nyman again, held a lengthy hearing on August 28th, 2025, after which Judge McCarthy found the defendant dangerous, but concluded that she could be released with conditions, including GPS monitoring with home confinement, except for medical and legal appointments with 48 hours notice to probation and no use of alcohol with monitoring by a scram device. Hold on one second while I write myself a note. I think we may need to get a recording of that hearing on August 28th, because the hearing that we listened to, I think, was the September 11th hearing, right? Yeah. The defendant's release was stayed pending a satisfactory home visit by probation. The defendant did not appeal. Okay. So remember, on August 28th of 2025, we were reporting on this, and the mainstream media was reporting that Kelsey was released to the custody of her parents, or her mom and her stepdad. And that turned out to not be true. She was not released on August 28th of 2025, even though the judge decided on that day that she could be released with conditions. The conditions were GPS monitoring with home confinement, because that ankle bracelet, we've learned that scram device on her ankle is only GPS, does not test for alcohol. And the scram device, I don't even know if it's a scram that's on her ankle. It's just a GPS monitor. The scram device is the one that she has to blow into for an extended period of time, a couple times a day. But the judge did not let her out, because she said that probation had to do a home visit to the home that she was going to move into with her mom and her stepdad. And then the Commonwealth goes on to say, when probation returned an unsatisfactory result, the court held another hearing on November 8th of 2025. Okay, that's the wrong date. It was not November 8th of 2025. It was September. Yes, this is the Commonwealth's responsive brief to the SJC full panel, if you're just tuning in. At which point the issue was resolved and the defendant was released. Well, no, she wasn't released on November 8th, okay? It was September 8th, and that's a big typo. And then again, they repeat that same typo again. Before the November 8th hearing ended, again, it was September, not November. We know because we were there. The defendant requested that the GPS condition be lifted the following day to allow her to undergo a medical procedure. However, the defendant submitted no evidence in support of her motion, and the motion was denied. Yes, Tim Bradle said, Your Honor, Kelsey's undergoing her, I don't know, 6th surgery tomorrow. And I don't think that a doctor will do surgery with an ankle monitor on. So would it be okay if right after her surgery, we come in to probation and have them install the ankle monitor on her then? And the judge said, yeah, no. Yeah, no. And so Kelsey had to cancel that surgery because the judge wanted proof that a doctor would not do a surgery with an ankle monitor on. And anybody who's in the medical field, or anybody who's has ever had surgery, knows that you even have to take your earrings off and your rings when you go in for surgery. Do you really think a doctor is going to do a surgery with an ankle monitor on? Come on, hold on. Two days later, the defendant filed an emergency motion for immediate relief from scram order, supported by affidavits from the defendant and her mother, and with an accompanying email from the probation department. Judge McCarthy held another hearing on September 11th of 2025, where a probation officer testified about the scram procedure and the defendant's apparent difficulty breathing deeply. Apparent difficulty. See, they won't even admit that she has difficulty breathing deeply. The Commonwealth is not your friend. Okay, they're just not. And it doesn't seem like any of the district attorney's offices in any of the counties have any integrity. It's maddening. It's maddening. Change my mind. Tell me one district attorney's office in the Commonwealth of Massachusetts that has shown some integrity. And I may be wrong. There may be some. I know which one. I know. I'll tell you. Me. Is it Bristol County where Sean Sousa has been released by the judge there and the Commonwealth has appealed it because Sean Sousa, who used to be a former Dartmouth police officer who was convicted by a jury of graping his 6 to 8-year-old stepdaughter and another girl who was 15 years old. Was that Bristol County? Yes. And who's the DA? What's his name? Tell me. The DA in Bristol County was so outraged because the judge, after Sean Sousa, former police officer, was convicted of the grape of his stepdaughter and another essay of another girl, after the jury convicted him and this same judge sentenced him, the judge decided to overturn the verdict, let him out of jail, and decided he's entitled to a new trial. So the Commonwealth is actually appealing that. And the briefs on that are due, I think, December 5th. And as soon as the briefs are in from the Commonwealth, they're going to review that because I'm outraged by that case. Tom Quinn is his name. Thank you, Virginia. There's one. We got one, you guys. We got one. Judge McCarthy held another hearing on September 11th, 2025, where a probation officer testified about the scram procedure and the defendant's apparent difficulty breathing deeply. At the conclusion of the hearing, the court removed the scram requirement because she did not want to, quote, torture the defendant and remanded her to custody. Thomas Quinn III. Thank you, everyone. Mad respect for Thomas Quinn III. Before the court could issue its 5-page written order later that day, the defendant filed a motion to reconsider because, how dare you? How dare you file a motion to reconsider before the judge even renders her decision? How dare you? The court denied the motion to reconsider in an 8-page decision on September 16th of 2025 because shocking. Nearly 3 weeks later, the defendant filed a petition pursuant to 211 and filed a supplemental exhibit on Monday, October 6th of 2025. The Commonwealth filed an opposition on October 15th, 2025. This single justice, Judge Dewar, issued a decision finding that Judge McCarthy did not make an error of law or abuse her discretion. The defendant petitioned for review by the full bench on October 27th, 2025, and the court ordered additional briefing on November 4th of 2025. The parties returned to the trial court on November 25th, 2025 for scheduling of a trial date. Oh, that's tomorrow. What time is that hearing? The Commonwealth anticipates being ready for trial in January of 2026. Oh, isn't that so awesome? They're going to be they think they're going to be ready for trial by January of 2026. So no big whoop if you hold Kelsey over until then, because, it's really not that long. Have they done discovery? Have they turned over the discovery? I have questions. It's at 9 a.m. tomorrow. Well, you know what's going to happen. I'm sure there's not going to be a Zoom. I'm sure there's not going to be any way to listen to that hearing. And does anybody know who the judge is? Is it going to be that same, Mastad says noon tomorrow. And Mastad, does it say who the judge is? Is it going to be that same? Nope, he retracted that. Nope. All right, I'll look it up. Statement of the facts. And the fact says the Commonwealth sees them. Statement of facts before Judge McCarthy, footnote 2. The facts set forth here are detailed in the police report that was part of the evidence submitted during the dangerousness hearing. Well, the facts set forth in the police report were not enough to indict KELSEY FITZSIMMONS on the attempted murder charge. I mean, I think it's, important to point that out. Contrary to the defendant's claim, the facts of the underlying allegation are hotly contested. At approximately 6 p.m. on June 30th of 2025, Lieutenant Sean Daly, Officer Patrick Noonan, and Officer Timothy Houston of the North Andover PD responded to Phillips Brook Road to serve the defendant with a restraining order. The defendant, a North Andover police officer, resided at Phillips Brook Road with her fiance, Justin Alayan, and their 4-month-old infant. Earlier that day, Alayan had sought and was granted an abuse prevention order out of Essex Probate and Family Court. Alayan alleged that the defendant physically assaulted him over the previous weekend and that he was in fear of her and for the safety of his child. He stated that the defendant had assaulted him in the past and feared that the defendant would hurt herself and the child if he were to leave. Nowhere in this pleading, nowhere in the police report does it ever say that KELSEY ever threatened to harm her child. Justin's fears should not be enough to conduct an ex parte proceeding to take a breastfeeding mother's baby away, in my opinion, without due process, without an opportunity to be heard. But that's what they did. I'm going to read that again. Justin stated that the defendant, KELSEY, had assaulted him in the past and feared that the defendant would hurt herself and the child if he were to leave. Along with serving the order, the officers intended to remove the defendant's firearms from the residence and transfer custody of the child to Alayan. Well, let me ask you a question. I don't know. I mean, I'm just brainstorming here, spitballing using context clues. If Justin feared that KELSEY would hurt herself and the child if he were to leave, just leave, what do you think should be the fear of what would happen if you were to take her baby away? Folks, do you think this was foreseeable? Did they think that it was just going to be, she was just going to be like, okay, fine, here, take my baby, have Justin come over and take my baby? They don't even have anybody from DCF there. They don't have any mental health professionals there. If you thought she was going to do that to herself and the child, you feared that. What do you think what do you think she might do if the baby was taken away? Right? He didn't call 911. He just went to the court to get an order. And she had just gotten her firearms back. She had been cleared to return to work on July 4th. This is June 30th. She had been out on leave from North Andover Police Department for postpartum depression. They knew all of this. This was foreseeable. Right. That's the question. Why were they not prepared with the appropriate people and channels? Thank you, Suzanne Hudson, for pointing out what is so obvious to everyone else here. This was foreseeable. After arriving at her home, the officers informed the defendant about the restraining order, advising her that she was required to relinquish her firearms and give Alayan the baby. What the F do you think is going to happen? You're walking into a woman's home. Let it also be known that she owned the home outright herself. His name was not on the deed. She's engaged to this guy. They get in a fight at her bachelorette party for still reasons unknown. 3 cops show up that she works with, her co-workers, and tell her, hey, babe, give us your gun. We know you just got your guns back, but we're here to get your guns. We're here to serve you with the restraining order. Oh, and by the way, Justin's coming over to take the baby away because we're doing that too. What do you think is going to happen? The defendant told the officers that her firearms were locked in a safe in the basement. Approximately 10 minutes after the officers arrived at the residence, they called Elaine to gather his belongings to take custody of the infant. Really? Really? Let me ask you a question. Where does Justin live? Remember we did the hearings and where does he live again? Where do his parents live? What town? Remind me, because remember there was a whole hearing where he said that he changed his driver's license to the town Stowe. Okay. How far is, I'm going to do it myself. How far is Stowe from North Andover? It's a different county, right? Isn't that Middlesex County? Hold on. But remember, he's a North Andover firefighter. Okay, it's 32 miles away. Okay. So it's about, right now, it would take me, if I were to drive there, 37 minutes on I-495. But 10 minutes after the officers get there, they call Justin. Was it set up? Was there a plan? Was he working that day? Was he waiting around the corner? I mean, come on. Do you think it might have been a better idea to maybe have Kelsey's mom take the baby? Do you think that could have been a better idea? Because Kelsey's mom did show up. I mean, I don't know. Every time I read about this, it just makes me more angry. I'm sorry. I'll try and calm down. Approximately 10 minutes after the officers arrived at the residence, they called Elaine to gather his belongings and take custody of the infant. Yeah. And that custody word sure is used intentionally, isn't it? Because coincidentally, like the next day, he went in to court by himself and filed for full custody of the baby and child support from Kelsey, something like that. Maybe the next day, the day after, I don't know. Maybe he let a day or two go by because, busy with an infant and all. In anticipation of Elaine taking the baby, the defendant gathered items, meaning Kelsey, for example, clothing, diapers, and bottles from around the house. Officers Houston and Noonan escorted her between rooms. After gathering bottles and diapers on the first floor, the officers escorted the defendant to the second floor so that she could get baby clothes. While they were on the second floor, Elaine and the defendant's mother arrived at the house. I mean, I don't know. I'm just, thinking. I'm not a mental health professional. I'm not law enforcement. I'm just a lawyer with 30 years experience, And if you wanted to de-escalate the situation of taking a woman's baby away, maybe, I don't know, you give the baby to her mom. There's so many other ways that this could have gone down. While they were on the second floor, Elaine and the defendant's mother arrived at the house, so he must have been waiting right around the corner. When the defendant heard Elaine, she asked Officer Houston to keep him away from her. Oh boy, she must have been mad. Wouldn't you be? It was her bachelorette party the weekend before. Maybe she broke up with him. Maybe she called off the engagement. Maybe she kicked him out of her house. And maybe in retaliation, he went into court and told the judge, oh, I'm afraid that if I say that I'm going to leave, that Kelsey might hurt herself or the baby. To maintain order, Officer Houston left the defendant and Officer Noonan on the second floor and went to monitor Elaine as he gathered belongings in the basement. Really? To maintain order? To maintain order, Officer Houston left Noonan alone with Kelsey and instead decided to go watch Justin pack up baby clothes in the basement? Right. Okay. Right. Lieutenant Daly remained on the first floor with the defendant's mother, Elaine, and Officer Houston. Well, I thought he just went into the basement. Which is it? Minutes later, he heard Officer Noonan on the second floor yell, and this is Daly who said this, Kelsey, don't do it. Kelsey, don't do it. Followed by 2 gunshots. He ran upstairs and rendered first aid to the defendant who had been shot once in the abdomen. Really? She was shot in the abdomen now? Are her lungs in her abdomen? It's right there. I highlighted it in pink because I couldn't believe it either. Are we trying to pull one over on the 7-judge panel in Massachusetts highest court by telling them that Kelsey was shot once in the abdomen? There were 2 gunshots. Where'd the other gunshot go? Right there. It says it right there, abdomen. Look, here's my cursor on your screen. Not a fly. And requested an ambulance to the scene. Lieutenant Daly. All right, well, they're spelling Daly 2 ways. Here, for the first time, they spelled it D-A-L-Y. And the second time, they spelled it D-A-L-E-Y. Which is it? Lieutenant Daly observed a firearm where the defendant was lying and moved it to the bed. Is that new information? Because I don't remember seeing that anywhere. That Daly found the firearm where the defendant was lying and moved it to the bed. I don't know. Maybe I did. I don't know. Officer Noonan explained that he was briefly alone with the defendant on the small second floor. The defendant was kneeling on the floor in her bedroom, folding laundry for the baby. While standing in the doorway, Officer Noonan observed the defendant face him, lunge behind the door, and reappear, pointing a firearm directly at him. Well, we've learned from not only the Zillow listing, but also Kelsey herself, that there is no door in her bedroom. No door. Not a door to the hall, not a door to a closet. There's no door. But it's their story and they're sticking to it. The defendant pulled the trigger and he heard a click, but no round fired. This is Noonan's story. The defendant began to stand up as Officer Noonan pulled his firearm out of its holster. As the defendant attempted to rack her firearm to chamber a round, Officer Noonan gave several commands, including drop the gun and don't do it. Well, unfortunately for him, nobody heard the drop the gun part because Officer Daly only heard him say, Kelsey, don't do it. Kelsey, don't do it, followed by 2 gunshots. Believing that she was trying to kill him, Officer Noonan fired once as the defendant continued trying to chamber a round. Officer Noonan fired a second round, striking the defendant. Okay, where did the first bullet go? Where did he fire it? Does anybody know? Did he fire it into the ceiling? You know, like Doug Benefield used to do to scare Ashley? Where did the first bullet go? Is he that bad of a shot that he missed her the first time? I have questions. And yeah, he struck her in the chest, not the abdomen. Section B, Superior Court 58A hearing. That's the dangerousness statute. At the 58A hearing in Superior Court on August 28, 2025, the Commonwealth submitted the state police report detailing the above facts, footnote 3. This was Judge McCarthy's second time considering the question of dangerousness with respect to the defendant. The Commonwealth also submitted an affidavit filed in support of a 209A restraining order filed in the probate court by Elaine on June 30th of 2025. The affidavit outlined that the defendant was, quote, heavily intoxicated and physical with others during an incident in Maine on or about June 28th, 2025, which was described as the defendant's bachelorette party. As the 209A order was issued from the probate court, a judge found that there was a substantial likelihood of immediate danger or abuse to Elaine. The materials submitted by the Commonwealth also included written statements made by Elaine and other people who were present during the incident in Maine on June 28th and the incident on June 30th. Through these statements, all right, what incident on June 30th? When she was shot? Through these statements, witnesses described the defendant as intoxicated, drinking heavily, and engaging in aggressive behavior towards numerous individuals during the June 28th incident. Who were they? Who were these witnesses? His family members? Truckers Against Tie Clips is here, and he says, let me get this straight. While she was pointing a gun at him from feet away, he was able to draw his weapon, aim, and fire before she could shoot him. Yeah. Well, it says that she pulled the trigger, but there was just a click, and then she went to rack her weapon again, and he shot once, and I guess I don't know where that bullet went, but his second shot, they say, went into her abdomen. We know from medical records it went into her chest. Yes, and Columbo 2.0 says, remember, this cop that shot Kelsey was a veteran officer. Yes, over 20 years on the job. Right? It was a magic bullet. Oh, happy birthday, Donna, New Hampshire woman. She's been here for 25 months. She's an OG. And it's her 58th birthday. Happy birthday, girl. Thanks for being here for so long. Thank you. KLM says they changed Kelsey from Zoom to in person for tomorrow's hearing. What is this hearing? If you know, it's supposed to be to set a trial date, as we just read in these papers, but I'm not sure if it's for anything else. But I was going to look it up in the docket in a second, so I'll do it right now. Thank you for your super chat. This is in Essex, right? Yeah. Mhm. 1 second. Right. Excellent comment. Dirt in my eye says, is he going to get heat? Nope. He's a cop too. Well done. Well done. Well, I can't find the right index number right now, so we're going to have to look again later and see what that is and exactly what time it is set for. But my understanding was it was supposed to be to set a trial date. Thank you, KLM. And Angie says, hey, Miss Melanie, thanks for all you've done and still do, because you made AJ aware of Kelsey's case yesterday, and even he says it's BS. Love you with all of my heart. Oh, Brother Counsel made AJ aware. Okay. Thank you. I love you with all my heart too, Angie M. Thank you for your 10. And Dana says, your opening song is my jam. Love being here from Halifax, Nova Scotia. Nova Scotia in the house. Thank you for tuning in from Canada and for your super chat. And Josh says, it's possible. I've witnessed New York sheriff deputies gown up to escort prisoners to procedure rooms before, even had gear under the scrubs. It's possible to do surgery with an ankle monitor on. I don't know any doctor who would do it. I know a lot of surgeons, and I know that that would be a very, very dangerous thing to do. I believe you, but you know, I don't know any surgeon that would do it. Thanks, Josh, for your 5. Mrs. Bouquet, I'll see you on the replay. My boys and well. Oh, Harrison, sending all the love. Thank you, Mrs. Bouquet. No worries. Watch next time. Watch it on replay. Thank you, Carol, for becoming a member. And Helena says, ambush, baby snatched by proxy, evil and calculated. Thank you for tuning in from Sweden. The world is watching. You are the world. Thank you, Annie, for your opinion on Justin. I appreciate you for being here for 6 months. Goes on to say, through these statements, witnesses described the defendant as intoxicated, drinking heavily, and engaging in aggressive behavior towards numerous individuals during the June 28th incident, the bachelorette party. The statements also reference prior similar behavior by the defendant. Well, I mean, by all means, take some ex parte stuff and just take a woman's baby away. Just take their word for it. Ipsy Dixit, because they said so. The defendant argued that she should not be found dangerous and moved that she be admitted to personal recognizance or reasonable bail under Section 57 of the bail statute. Defense counsel submitted reports from Dr. Nisevic, a doctor on the psychiatry service at Mass General, and Dr. Zizel, a licensed forensic psychologist. Based on the materials submitted by defense counsel, Dr. Nisevic opined that the defendant no longer met the Section 12 criteria, being a harm to herself or others, and is appropriate for outpatient care once medically stabilized and discharged. Through their motion, defense counsel requested that the court issue appropriate orders in the interest of justice set forth above, footnote 4. However, as Judge McCarthy noted, the defense did not submit any documentation regarding the defendant's physical medical condition as part of the dangerousness hearing. Not a single medical record or affidavit from a treating physician were submitted in either hearing related to the 58A district court motion, nor the Superior Court hearing. After argument from the Commonwealth and defense, Judge McCarthy found that the defendant was a danger based on the above alleged facts, her history of mental illness, and the defendant's out-of-state record, including public intoxication and disruption. Yeah, I think that was when she was like, I don't know, something like 18, 19, 20, something like that in another state. Maybe had a fake ID in a bar, something like that. I don't know. That's what's ringing a bell in my head. I could be totally wrong, but it was something that is kind of ridiculous to consider. And her history of mental illness, when you say her history of mental illness, what are you talking about? The postpartum depression that she had right after giving birth? Because what other history of mental illness did she ever have? I don't remember hearing any of that. But recognizing the change in circumstances from the District Court 58A bail review, where the defendant was also charged with assault with intent to murder, Judge McCarthy found that there were conditions of release that would provide the necessary protection to the community: GPS home confinement, residing with her mother and stepfather, compliance with mental health treatment, and abstaining from alcohol with scram testing. The defendant's release was stayed pending a satisfactory home review by probation. Oh, this is a continuation of that other footnote, which I didn't realize, but footnote 4 goes on to say, as part of their piecemeal litigation, defense counsel filed a medical notice to the court on September 5th, 2025, which was simply a filing by defense counsel and was impounded by the court. The defendant finally filed a letter signed by a medical doctor on September 15th, 2025, after the defendant had been remanded to custody and after the defendant filed the motion to reconsider. The one-page letter summarized the defendant's injuries and supported the claim that deep breathing may be painful, but did not indicate that deep breathing would hinder the healing process. And this is very repetitive for 41 pages. And it sort of just expounds on all of the things that we already read about, what the conditions were, that there was a home review done, that they had another hearing on September 8th, and that the judge released her on September 8th, pursuant to the previous conditions, that she wanted the ankle bracelet before that hearing even ended. She had surgery the next day, and she asked if they could install the bracelet after the surgery. And the Commonwealth goes on to say, however, the defendant did not submit any evidence that the defendant could not wear a GPS device during the procedure. The court denied the request. And then 2 days later, on September 10th, the defendant filed an emergency motion for immediate relief from scram order. The defendant claimed that she was unable to do the testing without experiencing severe abdominal pain and dizziness, and claimed with no medical support that the breathing impairs healing of her broken ribs and punctured lung. Because breathing into the scram device was, quote, physically impossible, the defendant could not, quote, comply with this order. The defense moved that it be vacated, end quote. The motion was unsupported by any medical evidence, but attached an affidavit from the defendant and her mother, and also an email from the Assistant Chief Probation Officer, Jeff January. Judge McCarthy held a hearing the next day, September 11th, 2025, and made abundantly clear her perspective on alcohol testing. When defense counsel framed the issue as a simple adjustment of terms, the court disagreed. I don't see it that way. I'm telling you, it's not a simple adjustment. One of the reasons she was released and one of the reasons to ensure the safety of the community was for her to be alcohol-free. If she cannot do that or will not do that, that changes everything. Defense counsel argued that although the defendant could pass the test, it was only with difficulty. At the court's discretion, PO January, probation officer January, was sworn, and he described the defendant's performance on the scram tests. No 5. Judge McCarthy indicated that she was surprised that the testing was not random, and that the defendant was apprised of a testing schedule. Right. And then it also was pointed out to her that in her order, she never said that it had to be random. He also observed that the defendant appeared to be in genuine pain during the setup process, and for that reason did not believe that failures to complete scheduled tests were willful violations of probation. The court also accepted the defendant's scram history as evidence. The Commonwealth, and this is the important part, if you tuned out, tune back in. The Commonwealth presented no evidence, but reiterated how important that the Commonwealth's belief is, in light of the court releasing the defendant, that testing be done. That's right. They presented no evidence. They did not oppose it, but they said, we do think it's important that you do monitor her for alcohol. But now they're taking a completely different position, which is wild. It's wild to me. After confirming that the defense had nothing further to present, the court heard argument from defense counsel. He reiterated that the test was only possible with significant pain and dizziness and having to recover for several hours. He argued that there's other ways to do this. If the court wishes to have her tested for alcohol, lack of alcohol, that's completely fine with the defense, but just the means that's employed is kind of a torture device for her. Cruel and unusual punishment and a potential 8th Amendment violation. And that, and these are my words, is when the judge spun out. However, contrary to his assertion here, defense counsel did not offer any alternative methods of testing. Oh, come on. It was all over the emails from probation that there was urine testing available at a facility. And the judge does this every single day. He knows what other methods of testing there are for alcohol. The court took a recess before issuing a decision. Here's the decision. I've reviewed everything, again, that's been submitted to me, and I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community, pursuant to General Law 276-58A. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to scram monitoring was necessary to ensure the safety of the community. After a thorough review of all the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Right? Claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the scram installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment to torture to continue to require Fitzsimmons to comply with the condition of being monitored by scram. The court concludes that Fitzsimmons cannot abide by the condition of being monitored by scram. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other officers in the community. Accordingly, the court's prior order of release is vacated and Fitzsimmons is ordered to be held without bail pursuant to the law, and a written order will follow. Footnote 6, listen to this. Although the defendant disparages Judge McCarthy in his brief, well, the defendant is a she, it's her attorney who is a he. and attempts to characterize her behavior as injudicious and short-tempered. The transcript reveals, transcript, not recording, transcript reveals that she presented the defendant with every opportunity to present evidence and make argument. After a recess, she issued her ruling from the bench and concluded the hearing. It was defense counsel who interrupted the judge, yelled to the bench after the hearing was concluded, and had to be chastised by a court officer for swearing. Well, that's new news. But you bet your ass the Commonwealth is going to take every opportunity to point that out. That Bradel allegedly had to be chastised by a court officer for swearing. Yeah, Zimmy's like, nice story. Yep. Then there's a motion to reconsider. Judge McCarthy issued a written order September 11th, but before it was docketed, the defendant filed a motion to reconsider. How dare they? Asking the court to release the defendant and order alcohol urine screens at a private facility. The defendant supported the motion to reconsider with an attached email from PO January from September 10th, in which he had responded that the only alternative to scram testing was urine screens at a probation vendor. In a 5-page written decision, Judge McCarthy Nyman denied the motion to reconsider, finding that there's nothing in the motion that was not known to the defendant or her counsel when this matter was last before the court on September 11th. There has been no change in circumstances or newly discovered information that would warrant revising the court's order or decision. The court reasonably concluded that the defendant's failure to transparently provide information related to her ability and willingness to abide by he's basically just spitting out all of the court's words, spitting all the court's words back to them. And we've read them 400 times. And apparently the, that footnote, we skipped this footnote, number 6. No, we didn't. Okay, moving on. Then they go on to talk about the urine testing. We were there. We saw all of this. I will scroll through this slowly in case you want to read it yourself. But I don't think I need to read it to you in any more detail because we've read this 100 times and it's just a regurgitation of all the same stuff. But what I do find interesting in the 41 pages, the Commonwealth goes on to say that everything that Judge McCarthy Nyman was right, that she did not abuse her authority, did not abuse her discretion, or commit an error of law. And they go on and on and on. All the same arguments they made the first time, except when it gets to the argument about the Americans with Disability Act, Americans with the ADA, they don't even mention it until page 31. Talk about dangerousness. It's not even a separate section. You have to search for it. It's all the way buried on page 31. And there's one paragraph that says, the claim related to the Americans with Disabilities Act is likewise baseless. The defendant cites no federal or state case addressing the intersection of the ADA and 58A, meaning the dangerousness statute. It appears to be an open question whether the ADA applies to dangerousness hearings. Okay, am I in the twilight? I feel like I'm in the twilight zone right now. Are there any lawyers in the chat? The question is whether the ADA applies to conditions of release, not necessarily the 58A dangerousness hearing. Because then they cite a case that says ADA applies to disabled prisoners, okay? And ADA applies to parole proceedings. And we must accord substantial deference to the professional judgment of prison administrators who bear a significant responsibility for defining the legitimate goals of a correction system and for determining the most appropriate means to accomplish them. I'm sorry, but wasn't Officer January, isn't he considered maybe peripherally a prison administrator? He's like head of probation. Hello? Hello? Chaka, please stand up. We're in the land of the lost. We're in the land of the lost. I don't know how they sleep at night. I really don't. Moreover, contrary to the claim that the defendant has a conclusively demonstrated disability, there is a dearth of medical evidence suggesting that the defendant's condition ever qualified her as a disabled person, or that the act of breathing deeply enough to submit a sample for the scram device was akin to an activity of daily living. I'm sorry. Is breathing not an activity of daily living? Am I completely being gaslit? Yes. Yes, I am. I am. Disability is defined as a physical impairment that substantially limits one or more of the major life activities of such individual. I don't know, like breathing. I need a chiropractor after this. Footnote 13 says the only medical evidence in this case was a treating physician's letter from September 15th, 2025, opining that a rib fracture can cause pain that may persist for several months after the injury, or that restrained bullet fragments could cause chronic pain that can be exacerbated by movement, such as deep breathing. Oh, I'm sorry. Is deep breathing not something that is a daily activity? I can't even believe that the Commonwealth in good faith can take this position when they took no position at the underlying hearing. The defendant's claim that she has severely diminished lung capacity is unsupported in the record. Right. Breathing into a scram device is a daily activity per her order. Exactly. Another good point. Thank you very much. Jen. And that's it. They dedicated how many paragraphs to the ADA? 1, 2, 3 paragraphs in a 41-page brief. In sum, Judge McCarthy acted prudently and deliberately in considering the Commonwealth's request for detention. She considered the evidence presented and made multiple supportable oral and written findings, resorting to detention as a last resort. The defendant has not demonstrated that she made an error of law or abused her discretion. Footnote 14. The Commonwealth reiterates that the defendant may request relief when the defendant is healed and able to perform the scram testing without pain, or if a new testing alternative becomes available. I don't know, like peeing in a cup. Everyone knows that's available. Probation recommended it. And you're evil. The Commonwealth is evil. Essex County DA, you are evil. You're evil. You could have done the right thing. You could have said, we take no position on this. We think it's totally fine. If you don't want her leaving her house to go have random urine testing at a facility, send someone to her house and test her. But to take a mother away from her infant, a breastfeeding infant, for no good reason other than you're just evil and you say so, just, it doesn't fly with me, and it shouldn't fly with you. Regardless of whether you think that Kelsey Fitzsimmons pointed her gun at Noonan. Because originally the judge said, okay, we're going to let you out. And even when the probation officer or the assistant chief of probation testified under oath, Kelsey was not in violation of her conditions and he would not violate her. She just threw her right back in jail. But don't worry. If and when you're feeling better, Kels, come on back. Make another motion. Tell the judge that you're willing to do it, which they actually did say during the hearing. She's willing to do it, but it causes her pain. Just come on back whenever you're feeling better. And you can always ask the judge again. Too bad it won't be in time for Thanksgiving. It's revolting. It's revolting. Conclusion: for the foregoing reasons, the court should affirm the single justice's finding that the motion judge did not abuse her discretion or commit an error of law. XOXO, Paul F. Tucker. Oh, Tucker. That has a nice ring to it, doesn't it? District Attorney for the Eastern District. Sorry, I usually don't curse, but sometimes you just can't help it. Sorry, it's 34 pages long, but really, altogether, it's longer because they attached some laws and stuff to the end of it. So it's like 41 pages altogether. I mean, come on, you guys, come on. Really? So this is what we're doing? Apparently. Charles Argo, thanks for tuning in from South Africa, says, I think Kelsey was clearing her weapon. First, she removed the magazine and then rack it to remove any round in the chamber. Then she dry fired the weapon. That's when partner panicked and fired. This is a misconduct cover-up. Thank you, Charles, for pointing out what everyone is thinking. You're saying the quiet part out loud. Right. Thank you so much for your super chat, for being the voice of reason. Thanks, Beata, for being here for 17 months. You do great work. Wish there was a ML in Toronto. Thank you very much for tuning in for so long. And on top, thanks for your super sticker. These new name changes that YouTube did to you guys is really screwing me up. Some of you, I can tell who you are. Like, I know this is on top, but it has reverted everyone back to like old usernames, or I don't know. It's weird. I don't like it. Charlie Lynn, thanks for your 10, says ADA's website says a physical or mental impairment that substantially limits one or more major life activities, i.e., or e.g., walking, speaking, breathing, concentrating, reading. Yeah. Thank you. Thank you, Charlie Lynn, for doing the Lord's work and for your 10. And Laura says, I had a mean girl boss just like Judge McCarthy, and she was itching to fire me. If not for the ADA, she would have. I pray that Kelsey gets the accommodations she deserves for her health and dignity. Thank you, Laura. Thank you, Laura, for your 10. Charlie Lynn says, no response to lack of due process, no notice, no proper hearing, no violation, and no reasonable alternative conditions cannot apply. Yeah. What else? You can always come back later and ask again. The same way that Judge Cannoni treated Karen Reed. There's no prejudice because, you're getting another trial. Don't worry about it, babe. You're getting another trial, so no big whoop, no biggie. Thanks, Charlie Lynn, for your 5. And Charles again from South Africa says, I broke all my ribs and punctured my lung. It's the exhale that is seriously painful. The rehab is blowing bubbles in water with a straw, right? For Kelsey, she had to exhale into that blow and go thing, that handheld scram device, for a long period of time. And it caused her so many hours of pain afterward. She could do it. which was painful. Judge didn't care. Norman says, this judge is walking something on wheels. Fill in the blank. Thanks for covering this, Melanie. Thank you, Norman. Thank you, Norman. Hold on one second. Before we switch over to Aaron Spencer, I just want to see if there's any other comments, but I gotta find something here. One moment while I look this up on the docket. Do, 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 do. Do, 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 do. 2577. Okay, back to the docket. Let me see if they have any more information on this hearing for tomorrow. Come on. Let's see. It is scheduled at noon tomorrow for a trial assignment conference in front of Judge Drexler or Dreschler. Drexler. I'm going to say Drexler. Drechsler. Thomas, the same judge who got mad last time when Bradel appeared on the phone because that's what he was told by the court to do, by the clerk, and said that all of the people that were interested in this case strained their technology. And as of right now, that is what it is intended to be. And Friday, Tim Bradel filed a motion for a writ of habeas corpus to produce KELSEY in person at court tomorrow and at all subsequent court appearances. It is like 2 hours each way from Chicopee to Salem, right? And it says that it's allowed for tomorrow, but all other dates will be considered depending upon the event scheduled, according to Judge Drexler. So I don't know if Judge McCarthy Nyman is off of this case. But as far as I can tell right now, KELSEY is to be appearing in person tomorrow at noon, unless anything changes. So, I mean, we can try to log in on the Zoom, but sometimes they just turn the Zoom off because they don't want us to see it. So I guess we're going to have to see. Is anybody going to be boots on the ground tomorrow? It doesn't look like they're going to hear the releasing tomorrow. I mean, the part about her getting released, that's in front of the appellate court now. That has nothing to do with tomorrow's hearing. That's unfortunate, but and then there's an order also in here that says, per the court, any further court dates are to be attended in person for counsel of record, meaning Tim Bradel can't come on the phone or Zoom anymore. He's got to go to Salem every single time. That is where we are right now with KELSEY FITZSIMMONS. Before we move on to Aaron Spencer, any other thoughts, questions, comments, concerns on that? Thank you, Betsy, so much for your Venmo. She says, thanks for always being real and speaking out for justice. And thank you, Betsy, for your Venmo yesterday when you said you were on replay. We missed you. Thank you, Elaine, for another very generous Venmo. Always appreciate you. She says she's going to go donate to KELSEY again. And she says some other things that I'm not going to read out loud because it might set off some ridiculous argument. Thank you so much, Elaine. I'll respond to you later. I appreciate you so much more than you even know. All right. Thank you so much, KLM 1266. And I did just look that up for you. And tomorrow's a trial scheduling hearing. So we know Kelsey's going to be there in person, and that he was granted for tomorrow only so far. Grace Bay says you didn't read the footnote where the Commonwealth accused Bradel of doing the appeal for publicity. I've been mad for days. I'm sorry. I just closed it out. Maybe that's part of it that I didn't read. Hold on a second. Can't keep all these tabs open because, it gets drafty in here. Let me see if I can find it real quick. What footnote number is it? I mean, there's a really long one here. Footnote 9. I don't know, that may be one of the only ones that I didn't read. Hang on. Footnote 7. Gray space, are you still here? Gray space. Paging, gray space. 7 or 8. Okay. Judge McCarthy also. Thank you. Footnote 8. Thank you very much. I will read this. Yeah, this is okay. This strains credulity. Thanks, Gray Space. This does deserve a special read. So let me bring that up. It's footnote 8. And we are still on Kelsey Fitzsimmons. Or now. Footnote 8 reads, 10 weeks have passed since the defendant was remanded to custody, and it is incredible to believe that her medical condition has not improved so that she would be able to breath, really? She'd be able to breath adequately into a scram device, really? It's incredible to believe that she wouldn't heal up in jail with, all the excellent medical care that she's probably receiving and all the germs. Tom McGinnis just can't even believe it. He's like, ha ha. But rather than file a motion to reconsider as suggested by the Commonwealth and single justice, defense counsel chose to utilize the somewhat protracted appellate process, perhaps to garner additional publicity and sympathy for his client. Yes, that's what they're saying, Charlie Lynn. They're saying that Bradel chose to allow Kelsey to rot in a cell to get publicity. Yes. Yes. And Michael says perhaps they should read the doctor's report. These injuries require up to a year to heal. And based on the way that Judge McCarthy Nyman has behaved so far, do you think that she would actually reconsider? Thank you, Grace Bays. And I can see why you've been mad for days after reading that footnote. Thank you, Nona to 3 for gifting a membership, and Kat Randall for gifting a membership. You guys are awesome. Spelling's not a big deal. Oh, please. They said earlier that the hearing was in November and it was really in September, and that scrivener's error was made twice in a row. No big whoop. It's just a big, giant Supreme Judicial Court, the highest court in the land of Massachusetts. Piper's mom says Noonan has tactics instructor for 8 years, specializes in de-escalation and control of various items. Pew pew. Really? Noonan specializes in de-escalation? I find that hard to believe. I mean, I believe you, but isn't that wild? Wow. Just wow. Yeah, I hate when people breathe, breath. And I hate when people spell trail. Two little pet peeves. That's all. That's all. Yeah, he did submit a motion for reconsideration that she immediately denied, but based on a change in her medical condition, that could have been another motion to reconsider. But it's gross. That's a gross thing for the Commonwealth to say. And so Paul Efford Tucker, Carmen knows your address, and that's just not nice. It's just not nice. Why can't you just be nice? Not that Susan says their grammar is a breathe of fresh air. Yeah. Mm-hmm. Scott McGinnis says hyperbole and vitriol must be a Massachusetts DA office filing. Yes, we do like Thomas Quinn III, though. So far, we like him. All right. Can we move on now? Maybe we move on? We need to move on. And we are moving on to Arkansas. We're going to Arkansas, babies. We're going to Arkansas. In the case of Aaron Spencer. And we're going to see what tomfoolery shenanigans and ballyhoo is going on over there in Arkansas. Because Arkansas might just be saying, hey, Commonwealth of Massachusetts, hold my bourbon. I don't know what they drink in Arkansas, but in Massachusetts, we used to say, hold my White Claw. But now we're going to say, tell me what they drink in Arkansas. All right, let's close that window. Let's keep that window up. Moonshine. Hold my moonshine. Well done. Well done. There was a lot of moonshine in there. Aaron Spencer for sheriff. They really, 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 really do not want Aaron Spencer to be sheriff. Wait till you hear this. Oi. Hold my Arnold Palmer. No, hold my moonshine. I love it. Hold my moonshine. I thought I had another thing up here, but let me pull it up again. The Aaron Spencer trial is coming up beginning of next year in January. The final pretrial conference is early December. I'll get you the real dates in a minute. And so we are in the motion in limine phase. Motions in limine, just to give you a little refresher, are filed before the trial so that both sides know what evidence is going to be allowed in and what evidence is not going to be allowed in. And so if you specifically want something in, you make your motion in limine. If you specifically want something excluded, you make your motion in limine. Some judges decide them ahead of time. Some judges, like Judge Frenier is doing in the Brian Walsh case, admit that trial is a living, breathing thing. And so therefore we have to decide as we go along what things are going to be allowed in and what things are not going to be allowed in. Motions in limine is what the closed captions called them one time. And we have allowed it and we've adopted it. And so one of the motions in limine so far that Aaron Spencer has filed, we already went over this. It was filed on October 1st, but I want to do a quick review of it before I show you the response from the state of Arkansas. So all the way back on October 1st, Aaron Spencer's attorneys made a motion in limine to exclude evidence of Aaron Spencer's conduct from July of 2024. And we read this motion. And we're going to breeze through it. And if you are not familiar with the Aaron Spencer case, by reading this motion, it's going to tell you everything you need to know for purposes of today's discussion. And really, it tells you all about the whole case because there are not a ton of filings in the case. But I think this deserves repeating. Hold on, because it was a long time ago that we went over it. Comes now, defendant Aaron Spencer, and for his motion states, decedent, that means him dead. Decedent Michael Fosler was charged with multiple felony counts for essaying Spencer's daughter in this case number. Fosler was arrested on July 11th, 2024, after Spencer's daughter made initial disclosures on July 8th of 2024. He was charged with something like 43 felonies. A little extra backstory on Michael Fosler. He was, I think, 67 years old. In years prior to this incident involving Spencer's daughter, he was the chief of police in a town called Hamlet, Indiana. Fosler was, because you know why? Because you just can't make it up. And another victim of Fosler has come forward and has spoken to a TikToker YouTuber. And she has disclosed that she too was also abused by Fosler all the way back in, I think, the 80s, when he was the chief of police in Hamlet, Indiana. And that what happened to her was so egregious that her mother falsely reported her as a runaway and sent her to Arkansas to live with her dad. And in this interview, she also said that during the incidents with Fosler in the bedroom, she used to babysit for Fosler and his wife. That's how they knew her. She was their babysitter. But during these horrific acts, Fosler's wife was present. Fosler's wife is now dead, as is Michael Fosler. That prior victim from the 80s also said, after her mom sent her to Arkansas to live with her dad, that when this hit the news about Michael Fosler being shot by Aaron Spencer and killed, that she was horrified to find out that Michael Fosler lived within walking distance of where she lived in Arkansas. I know it's horrific. We've done a lot of shows on Aaron Spencer. So if you didn't watch that one, the playlist is linked below in the show notes. The state's discovery file contains a report from Lonoke County Sheriff's Office Deputy John Ingram about a meeting with Liana Higginbotham and her daughter, Paula McFarland, on July 8th of 2024. Okay, so that would have been the same day that Aaron Spencer's daughter initially disclosed the abuse, which for a 13, 14-year-old girl is really soon, within a couple of months of it happening. Many victims and survivors of SA do not disclose ever, especially that young. So it's amazing that she disclosed so quickly. But the same day of her disclosure, Lonoke County Sheriff's Office, the same sheriff's office that Aaron Spencer is running to be sheriff of, coincidentally, met with Liana Higginbotham and her daughter, Paula McFarland, on that day, July 8th, 2024. The report alleges that Higginbotham and McFarland told Ingram that Aaron Spencer had requested details about their, quote, mutual friend, Michael Fosler, and that when Higginbotham and McFarland asked Spencer why he wanted Fosler's information, Spencer told them that Fosler had raped his teenage daughter and allegedly begged for them not to call the police. Ingram's report then notes that he spoke with Spencer at his residence and that he was extremely angry at first and refused to talk about possible grape, but then calmed down and cooperated fully with law enforcement's investigation into Fosler. Aaron Spencer's attorneys go on to say that the court must exclude any reference or evidence about Spencer's conduct on that day because the conduct has no independent relevance, doesn't fall into any of the known exceptions to character evidence. Any probative value outweighs its prejudice and confusion of the issues. And so they want it out. They want whatever happened, whatever interview the deputy sheriff did with Aaron Spencer about him going over to these people's houses and saying, do you know this guy Fosler, etc. They want it out. Their argument is that the evidence is not relevant and inadmissible because Spencer's conduct in July of 2024 has no bearing on whether his use of force against Fosler more than 3 months later in response to Fosler kidnapping, essaying, and possibly eliminating his daughter as a witness in his own criminal case was justified. Evidence must be excluded as irrelevant. And that's what they're asking the judge to do. They're saying that prior bad acts evidence must be independently relevant to the main issue. It is not relevant to the main issue, and therefore you should exclude it, Judge Barbara Elmore. And that it also should be excluded because the state is not entitled to introduce evidence of other offenses to try and persuade the jury that the accused is a criminal and thus likely to have committed the crime that he's been charged with. They're saying it's irrelevant because whether Spencer asked associates of Fosler for information about Fosler more than 3 months prior to the charged acts in this case has no relevance to the charged acts. Whether he was angry and or initially refused to cooperate with law enforcement into the investigation with Fosler has no relevance to the charged acts either, because he did fully cooperate after he shot Fosler dead. And then they go on to say such evidence may be relevant if Spencer was alleged to have stalked Fosler and killed him at his home or out in public. However, that is not what happened here. Rather, Spencer awoke in the middle of the night to find his teenage daughter missing and happened upon Fosler's truck as it turned down Spencer's street while out searching for his daughter. Spencer was not out looking for Fosler. Rather, he was looking for his daughter. He just happened to find Fosler with his 14-year-old daughter mere months after Fosler's arrest for essaying her. What followed was a lawful use of force in defense of his daughter and himself. And so they are saying because of that, the state should not allow in this interview in July. We're going to find out more about this interview now and that was filed on October 1st. And the state did not respond to this motion in limine until they filed their response on November 14th, because, 6 weeks, whatever, no big whoop. Take this down and show you the state's response of why they think it should come in. You can decide whether you think that the state of Arkansas wants Aaron Spencer to be sheriff. Sorry, this was filed on November 7th. Okay, so the first motion in limine, that motion in limine we just read was October 1st. The state's response was filed on November 7th, so that's like 5 weeks later. And here's the state's response to defendant's motion in limine to exclude evidence. Aaron Spencer is charged with murder in the second degree and the killing of Michael Fosler, hereinafter Fosler. Nope. Come on. That doesn't want to let me highlight. It's kind of weird, but whatever. But I need something. I need a red pen because it helps me find my place. Okay. The chain of events leading to Fosler's murder began on July 8th of 2024, when defendant arrived at Liana Higginbotham's house, an acquaintance of Fosler, and told her that he had raped his minor daughter and wanted Fosler's phone number and address. Spencer told Higginbotham, "Don't call anyone. Don't call the police." Well, this is going to get interesting. Wait till you see the reply to this. Hang on. Out of concern, Higginbotham spoke with a family member about her interaction with Spencer. Her family member, a mandated reporter, was required to report the rape allegations to law enforcement and reported them to the Lonoke County Sheriff's Office. That same day, Sergeant John Ingram and Deputy Brian Duke of the Lonoke County Sheriff's Office responded to Spencer's residence to open an investigation about the rape allegation concerning his daughter. All right. Mandated reporters in Arkansas include, because I looked it up for you, childcare workers, dentists, law enforcement, school employees, clergy, and medical personnel. Hang on. I don't know. That's like hearsay, though. It's like Aaron Spencer did not tell the mandated reporter. Aaron Spencer told Leanna Higginbotham, who told a mandated reporter. See the difference? The interaction was recorded by Sergeant Ingram on his body-worn camera, and a transcription of the relevant portions are included as attachment A. Oh, just the relevant portions. Okay, I see. Just give the judge just a little taste of it. Don't transcribe the whole thing. Sergeant Ingram asked Spencer, "Is there any truth to this?" Spencer replied, "I don't know." About the grape. While attempting to investigate the allegations, Spencer was mainly concerned about the identity of the mandated reporter and his beliefs in the inadequacies of the judicial system. Sergeant Ingram stated to Spencer, "We still don't live in a country where you can take the law into your own hands." Spencer responded, "BS," but he said the word. It's the attachment A. Eventually, Spencer's wife, Heather Spencer, provided information to the deputies regarding the SA of their daughter. Spencer's daughter was interviewed at the Wade Knox Children's Advocacy Center on July 8th of 2024, the same day. Cabot PD obtained a warrant on July 11th of 2024 for Fosler's arrest on one count of grape and one count of internet stalking of a child, both Y felonies. Fosler was arrested that same day and taken to Lonoke County Jail. Fosler was seen at his first appearance hearing after arrest by a Lonoke County District Court judge on July 12th of 2024, and his bond was set at $50,000. Yes, notice how they don't point out that the Lonoke County District Court judge is Judge Elmore, the same judge who is going to try Aaron Spencer, the same judge who arraigned Aaron Spencer, and the same judge who's going to oversee the trial and decide this motion. Can't make that up, can you? Fosler was also ordered not to have contact with any minor, a violation of which would result in his bond being revoked. Fosler made bond on July 17th, 2024, and was released with conditions of pretrial release, including the no contact order. So $50,000 bond is equivalent to $5,000 in cash. And it doesn't say here whether he remained incarcerated between July 12th and July 17th, because the entire Fosler file is sealed. And he was eventually charged with something like 43, 47 felonies. Right. And they just sort of like brush right by this. Yeah, no contact order, restraining order. Don't go anywhere near the girl. Don't go near the girl. Give us $5,000 and you can get out. It's outrageous. On October 8th of 2024 at 1:12 a.m., Heather Spencer, that's her mom, called 911 to report their daughter was missing. Heather Spencer said they found their daughter's bed made up to look like she was asleep, but was not in the bed. Consistent with Spencer's beliefs expressed to law enforcement on July 8th of 2024, Spencer proceeded to take the law into his own hands. Spencer later told investigators that he immediately got into his truck to look for Fosler, stating, quote, he was vigilant for him. Spencer left his home traveling westbound on Highway 236. Spencer stated as he was turning onto Highway 31 at the intersection of Highway 236, he saw Fosler's white Ford truck pass him, turning onto Highway 236 eastbound back towards Spencer's house with his daughter in the passenger seat. Spencer turned around and began following Fosler. He was honking and flashing his lights in an attempt to stop Fosler. After following Fosler for approximately 6 miles, Spencer struck Fosler's truck containing both Fosler and Spencer's daughter. As a result, Fosler's truck was rammed into a ditch, striking a wooden entry gate post. After exiting his vehicle, Spencer then began to fire on Fosler. Spencer continued to fire a total of 16 times. 15 of 16 rounds entered Fosler. After firing, Spencer pistol whipped Fosler in the face. Then, for the first time that night, Spencer finally called 911 at 1:34 a.m., stating, "Michael Fosler is effing dead on the side of the road for trying to kidnap my daughter. I had no choice." Let's go back, because they're not telling the whole story. Heather Spencer is very vocal on Facebook. There's a Facebook page. That too is linked below in the show notes to support the family, as is the Give, Send, Go. The first 911 call notified law enforcement about Michael Fosler and that they had a stay away order against Michael Fosler and that he may be involved with their daughter's disappearance. They don't put that in their papers, though, do they? No, they didn't put that in there. Did law enforcement do anything? Did they go out looking for her? This is at 1:12 a.m. "22 minutes later is when Spencer called 911. And by the grace of God, somehow he left his house looking for his daughter and by the grace of God found her. I don't think she would have made it home alive that night. Do you? She was the only witness against Fosler whose trial was coming up in December of 2024. Do you think she would have made it home alive? I don't. After the state of Arkansas says Aaron Spencer, then for the first time that night, Spencer finally called 911 at 1:34 a.m. stating, "Michael Fosler is effing dead on the side of the road for trying to kidnap my daughter. I had no choice." In fact, they say, Spencer had multiple choices that night. Spencer could have called 911 once he discovered Fosler and his daughter. Spencer stated in his interview that he was driving so fast that he could not unlock his phone to call 911. However, a forensic examination of his phone from the minutes leading up to Fosler's killing paints a different story. Not only does the examination show that his phone was unlocked, but it was in use. Spencer had a 1-minute, 39-second phone conversation with a family member at 1:16 a.m., received multiple text messages marked red, and called his wife twice around 1:31 a.m. before calling 911. Spencer also had good reason to believe his daughter had snuck out of the house and had not actually been kidnapped that night. Really? Really? I'm going to blow your ears out right now when I say to you, she was 14. She was 14. She could not consent to anything that disgusting 67-year-old monster did to her that night. How dare you make it seem like Aaron Spencer's daughter went with this man willingly? How dare you? They had a restraining order against him. He was charged with 40-something felonies against her. And the state of Arkansas wants the jury and you, the world, to believe that Spencer had good reason to believe his daughter snuck out of the house because she wanted to be with Michael Fosler. Are you effing kidding me? Yeah, they're victim blaming a 14-year-old. That's exactly what they're doing, Carla from Ohio. He raped her when she was 13. I believe When Fosler met his maker, she was 14. And this is revolt. Yeah, it sounds exactly like Robert Devine. That's right, Denise. It does. Just wow. Just when you thought Massachusetts was the worst, Arkansas comes in and says, hey, hold my moonshine. Spencer did not want police involved when he initially discovered his daughter was SA'd, nor did he want them involved when he found Fosler with his daughter. Spencer's understandable rage did not give him the legal right to kill Fosler. His belief, espoused on July 8th, 2024 to Sergeant Ingram, that it was BS that we still live in a country where you cannot take the law into your own hands, runs counter to our entire justice system. Evidence that the defense wants to exclude regarding Spencer's statements wherein he clearly indicated he did not wish police involvement in his daughter's grape investigation, his implicit comments that he could take the law into his own hands and should not be charged with a crime, are directly related to his actions on the night of October 8th of 2024, which are exactly 90 days later. What did he do for the 90 days in between? Did he stalk him? Did he threaten him? Or did he try and let the justice system work itself out? That's what the jury is going to need to decide. Not only are the statements by a party opponent, the evidence is clearly also admissible under Rule of Evidence 404B, which allows evidence of other acts that are admissible to provide to prove motive, intent, plan, and knowledge. Evidence is relevant if having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Spencer's affirmation that one can take the law into one's own hands makes the extrajudicial act of killing Fosler more probable, done without any consideration of the law on self-defense or the defense of others. Wherefore, the state requests that this court deny defendant's motion and allow this testimony to be elicited by the state in their case in chief as a statement by a party opponent and or under Arkansas Rule of Evidence 404B. XOXO, John Huggins, Chief Deputy Prosecuting Attorney. And now we turn to the body camera transcript, but just selected portions, of course. And so just to refresh your recollection, this is Sheriff Deputy John Ingram. And then there's an officer. Hold on a second. Sergeant Ingram and Deputy Brian Duke of the Lonoke County Sheriff's Office. So they go to his house. So now they're at Aaron Spencer's house. And this is recorded by Sergeant Ingram's body-worn camera. Ingram. Hey, sir. Officer. I don't know what officer this is because it doesn't say, it just says officer. He's gonna, something inaudible, by the way. Ingram says, are you Aaron? Spencer says, y'all creeping around here? What's going on? Ingram says, we're not creeping around. We're just trying to make contact with you. Hang on one second, please. Hold on. Y'all creeping around here? What's going on? Says Spencer. Ingram says, we're not creeping around. We're just trying to make contact with you. Spencer says, with me? Ingram says, Aaron Spencer? Spencer says, what do you need to make contact with him for? Ingram says, well, we've got a report from a mandated reporter that your child may have been involved with a grape situation. And so we needed to talk to you about it. Spencer says, who's the mandated reporter? Ingram says, well, it's a mandated reporter. Spencer says, cool. Who was this? Who was that? Ingram says, well, I'm just letting you know. So, I mean, is there any truth to this? And Spencer says, I don't know. Ingram says, you don't know? Well, would you like to talk to us about it? Spencer says, I'm not sure. Ingram says, okay, we're just, Spencer says, I'm not sure what's going on. Ingram says, we're just here to help. Spencer says, you got any more information than that? Ingram says, well, here's what we were told. We received a call to our dispatch, and then there's a male voice that says, who called you? Ingram says, sorry, a mandated reporter had to call us. Someone that you spoke with earlier is a mandated reporter who's she has to report what she heard you say. And there's a male voice that says, and who's that? And then Spencer says, so who heard me say what? What did I say? A male voice says, has something been called before? Ingram says, what's that? Male says, has something been called before? Ingram says, no, but I'm explaining it. If we get a call saying that there was potentially may have been a child who was raped, male says, uh-huh. Ingram says, then obviously we have to respond. The person gave your name as the person who was the father of the child who may have been raped. Spencer says, okay. Ingram says, so obviously we have to come and talk to you and see if there's any truth. Spencer says, who called and made these allegations that something might have happened? Officer says, sir, that's really irrelevant. We're just asking. Spencer says, it's not irrelevant. Officer says, it is. It really is. I mean, we're here for the child. Spencer says, then let's play the guessing game then, right? I mean, come on. Ingram says, no, you probably know who you spoke to today about looking for some person's address. I mean, let's. Spencer says, who? Ingram says, a Mr. What was it? Mike Folsom or something? Folsom, Mike Folsom or something? Really? They didn't do their due diligence to look up if there were any charges against a guy for what happened to the daughter? Well, actually, no, that's because there were no charges yet. Sorry. This is when again? This is the day that she disclosed, July 8th. Sorry, never mind. I take it back. Mr. What was it? Mike Folsom or something? And Spencer says, who's that? Who's that? Ingram says, okay, well, I mean, we're trying to help, okay? And Spencer says, are you? Ingram says, yes, but we can only help so much. If you're not going to talk to us, then obviously we can't. Spencer says, I'm just wondering who called you saying that there was somebody that was harmed and that. Ingram says, no one said anybody being armed. Harmed, H, says Spencer. Ingram says, harmed, okay. Spencer says, yeah, I'm carrying. Ingram says, yeah, I can see you carrying. Still, Spencer says, I'll keep my hands up here so nobody gets. Ingram says, that's fine. I mean, again, we're not here to cause any problems for you. Spencer says, okay. Ingram says, we just need to investigate. Officer says, we're not the bad guy. We're just trying to help. Ingram says, yeah. Officer says, I understand. I understand your emotional feelings. And then there's something inaudible for 3 seconds. Spencer says, let me ask you a question. Officer says, so I understand. Spencer says, let me ask you a question, okay? Officer says, yeah. Ingram says, yep. Spencer says, if those allegations are true and there was a child that was raped, okay, what's going to happen to that man when you arrest him and prosecute him and this and that? 3 to 5? What? He's rolling around, cruising, grooming? Officer says, like I said, I understand. I have a kid. Spencer says, no, seriously. So if that happened to your kid, right? And then the officer said, it did. And it did. Spencer says, and you went to the police? Officer says, uh-huh. Spencer says, and how'd that work out? Where's he? Where's the accused today? And the officer says, in prison. Spencer says, he's in prison? Is he serving life? Officer said, no. Spencer says, no, he's going to get back out, isn't he? Officer says, like I said, I understand. Spencer says, he's going to get back out and he's going to go around and F more kids, okay? So do you think that it's logical for people to come to the police when they can't do anything about the situation? If somebody was harmed, Ingram says, yeah, but can I say, officer says, hypothetical, let me ask you this, okay? Let's say, for instance, someone was raped. Spencer says, uh-huh. Officer says, and the father, rightfully so, not rightfully so, but understandably so, was upset, took the law in his own hands, understandably. Trust me, I understand, and does something. And that father ends up going to prison. What is that? Where does that leave the little girl? Spencer said, why would the father go to prison? That'd be weird. Officer says, hypothetically. Spencer says, hypothetic, right? Officer says, hypothetically, if he does something. Ingram says, we still don't live in a country where you can take the law into your own hands, okay? Spencer says, bullshit. And we have a button for that. Where's the button? It's right here. Ingram says, okay, well, and then Spencer says, if the judicial system can't do a better job. Ingram says, okay, well, then you'd have to face the consequences and possibly take a charge with manslaughter and Spencer says, well, hypothetically, maybe that rapist and that father can share a jail cell. And maybe that rapist could be that father's little effing biatch. And Ingram says, well, that wouldn't happen. And Spencer says, you know what I mean? Officer says, but you know who pays the price of all that? Spencer says, it's the child, ultimately. Ingram says, yes. Officer says, it's the child. Spencer says, obviously. Heather Spencer then says, but see, here's the deal. Her life has already been ruined now, hasn't it? That's a mama bear for you. And Aaron says, yep. Officer says, so don't ruin it anymore. Heather says, so what can we do then? Can you guys get him? Go get him? Can you put him in prison? And Ingram says, well, I mean, we have to do our investigation, obviously. Yes. And that is where the transcript ends. BB Collins says, so they're trying to frame this as being premeditated based on this conversation. This is BS. Yep. Exactly. And Sarah says, future sheriff Spencer, please adopt me. And SWT says, I know as a mandated reporter myself, at least in Illinois, we don't report on any hearsay or rumor. And that's where the transcript ends, because they only transcribe the pertinent portions. But to me, you know what this shows me? This shows me that whatever they said to Aaron Spencer made a difference. And he didn't go chasing after Fosler that day and take his life that day. It goes to show me that they actually did wait for Fosler to be arrested. And they did wait. And Fosler got out on $5,000 bail. And Fosler was charged with 43 felonies for what he did to their daughter. And months went by and Fosler was out of jail. And it took Fosler kidnapping his daughter in the middle of the night to enrage Aaron Spencer to the point where he went out to look for his daughter, and what happened. And, sometimes we put Dexter up there in the corner because it's the oldest defense in the book. Justifiable homicide is he needed killing. Doesn't sound premeditated to me, because this was 3 months before it happened. That is the real crime, says Max, that he was out. That was the real crime. And just like Spencer said, he'll do it again. And let me tell you another little story about Judge Barbara Elmore and what happened recently. We covered this a couple weeks ago. There was a 19-year-old kid who was arrested and charged with raping a child. He too, again, same judge, Judge Barbara Elmore, let him out on very minimal bail. He was charged with several felonies with regard to raping a child. Let him out. We don't know how much bail, because again, it was sealed. A couple months later, maybe even a month later, same kid same rapist is arrested in Polk County for raping another child. And now he's being held in Polk County on a $500,000 bond. So Barbara Elmore seems to be a pattern with her. And Aaron Spencer was right. And we're going to find that out because now we're going to look at Aaron Spencer's reply to this filing by the state. And we're going to find out a couple of new things. Here's the reply that was filed November 14th. This is going back to Kelsey. Thanks. 302 Girl says on LinkedIn, Noonan is currently a special tactics instructor. Looks like my message won't send. If I place in chat, one is escalation. What? De-escalation? I'm not sure. 302 Girl. But that's what I guess you were saying from your earlier super chat, was that it's what it says in LinkedIn, is that he's a de-escalation specialist. This is the reply to the state's response to defendant's motion in Limine to exclude this evidence of what happened in July of 2024 when Aaron Spencer went to the neighbor's house. Hold, please. Defendant Aaron Spencer, by and through his attorneys, Aaron Castanelli and Michael Kaiser, states for his reply to the state's response to the motion in Limine to exclude evidence. Spencer is charged with second-degree murder of Michael Fosler, specifically that Spencer knowingly caused the death of Fosler under circumstances manifesting extreme indifference to the value of human life. Spencer has asserted the defense of justification pursuant to the Arkansas Code. And here is the definition of justification, which is another word for self-defense. A person is justified in using deadly physical force upon another person if the person reasonably believes that the other person is, 1, committing or about to commit a felony involving physical force or violence, 2, using or about to use unlawful deadly physical force, or 3, imminently endangering the person's life or imminently about to victimize the person from the continuation of a pattern of domestic abuse. Spencer has also asserted a defense pursuant to Arkansas Code 52604. Conduct that would otherwise constitute an offense is justifiable when, 1, the conduct is necessary as an emergency measure to avoid imminent public or private injury, and according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweigh the injury sought to be prevented by the law proscribing the conduct. Both statutes are justification defenses under Arkansas law. The state's charge requires proof beyond a reasonable doubt that Spencer knowingly caused Fosler's death by deliberately creating a risk that was practically certain to result in Fosler's death. The state must further prove that Spencer did not act under the reasonable belief that Fosler was committing or about to commit a felony involving force or violence against Spencer or Spencer's child, or that Fosler was using or about to use unlawful deadly physical force against Spencer or his child, and that Spencer's conduct was not necessary as an emergency measure to avoid an imminent public or private injury, and the desirability and urgency of avoiding it outweighed the injury sought to be prevented by the murder statute. Both defenses are to be submitted to the jury if there's any evidence admitted supporting the defense, and if so, the court shall charge the jury that any reasonable doubt on the issue requires the defendant to be acquitted. Thus, the state must disprove those defenses beyond a reasonable doubt. Roman 1. The state's factual recitation is misleading and omits material facts. The chain of events that led to the death of Michael Fosler began in July of 2024 when he repeatedly, okay, hold on a second. The chain of events that led to the death of Michael Fosler began in July of 2024 when he repeatedly sexually violated Spencer's daughter. Not, as the state would have it, when Spencer first learned of the horrors Fosler had perpetrated against his child. The chain of events that resulted in Fosler's death definitely began with Fosler repeatedly essaying a then 13 and later 14-year-old child. So now we know it was repeated. It wasn't a one-time thing. The chain of events continued with Fosler being arrested and released for those crimes, yet continuing his manipulation and deception so he could continue assaulting the child until finally someone realized that he had taken her away from her home during the night. And I did not know, this is new information to me, that after July and until the night that Fosler took the child from her home, he repeatedly assaulted her. Is there a jury in Arkansas that's going to convict this man? Wow. No, this trial will not be televised. It will not be. Footnote 1, which reads, it seems that the state is sensitive about the language used to describe the 67-year-old Fosler picking up his 14-year-old SA victim so he could take her to another location to commit more S crimes against her. But surely no one can argue that he did not take her away from her home in his vehicle that night. When Fosler realized that the Spencers realized that he had taken control of her that night, he fled with her, refusing to surrender her. The chain of events that led to Fosler's death began and ended with Fosler's criminal acts. The state's suggestion that the chain of events that resulted in Fosler's murder was Spencer's looking for information about Fosler from the mutual acquaintance is yet another attempt to distract from the, quote, chain of events that Michael Fosler started and perpetuated until his death. It is yet another deeply concerning indication of its failure to blame the blameworthy, the dangerous pedophile, instead of the man who found his daughter under the control of the pedo. And while the pedo was facing multiple life sentences and then some for his abuses of her. The state also repeatedly manipulates the statements and evidence in its response. For instance, the state says that Spencer told Higginbotham, quote, don't call anyone, don't call the police, although that is not precisely what Higginbotham told police shortly after. When he came to speak with Ms. Higginbotham, the person through whom Fosler accessed the child, Spencer actually said, don't call anybody. She felt because a family member had been through a child SA incident and the local police department in this jurisdiction had re-victimized her instead of helping her. Okay, we got a lot to unpack here. Higginbotham is the woman through whom Fosler accessed his daughter. It seems that, as we read on, we are going to find out that Ms. Higginbotham was the girlfriend of Michael Fosler. And so Spencer found something out. And he found out who she was. And he went over there to find out who he was. She explained that Spencer had just learned of the assault from his daughter, although she did not seem to believe it was true. And he wanted Fosler's contact information. Okay, so let me get this straight. So she goes to the... No, she didn't go to the police. She didn't go to the police because he was accusing her boyfriend of graping his daughter. She didn't go to the police. She told her friend that her boyfriend graped Aaron Spencer's daughter, and then the friend went to the police because the friend is a mandated reporter. Okay. The state also omits the context as to the history of the family connection between the Spencers and Higginbotham and her role in the events that led to Fosler's abuse of the child. So is there a family connection between the Spencers and Higginbotham? It's a fly. The state's response then purports to describe the events when officers arrived at Spencer's residence in regard to the grape allegation. In addition to the family's knowledge of local law enforcement's failure to assist in a prior child SA investigation, Spencer knew that Fosler had a history in law enforcement and the military. Although the state focuses solely on Spencer's visceral reaction to learning the details of his daughter's repeated grape by Fosler, the reality is that within about 7 minutes, the Spencers agreed that the child would speak to a female officer, and the conversation moved to exchanging information and proceeding with an investigation. Spencer and his wife then spent the next hour and 8 minutes or more talking with officers about the family history, the situation that led to their child interacting with Fosler, and information the child had reported to her mother, while waiting on other officers to respond and filling other time with cordial discussion about everything from the military to animals to movies. Spencer and his wife invited the officers to park in the driveway, invited them to sit on the porch, and offered them water. They completed forms and signed paperwork, answered questions, and cooperated with the officers' requests. After waiting for nearly an hour, an investigator arrived and explained that another investigator would be assigned to the case, so she would not be speaking to the child that day. She interviewed the Spencers, and they provided her with all the information she requested, including names, contact information, and every detail they knew to that point. They agreed to wait for a detective to contact them the following day to set up an interview with the minor. Spencer thanked the officers for coming, and they cordially departed. The state's attempt to reframe this interaction as one in which Spencer was mainly concerned about the identity of the mandatory reporter and his beliefs in the adequacy of the judicial system is not just false, but completely tone-deaf as to the situation the Spencer family suddenly faced and their fierce concern for their child. The state dismisses that Spencer did not refuse the officer's entry or refuse to cooperate or allow his child to cooperate. Certainly doesn't acknowledge the more than an hour he and his wife providing officers with any information they could to help put Fosler in jail. While Spencer was worried for his child and angry at his daughter's grapist and the person he felt protected the grapist and who they believe lied to officers, he was quickly calmed and cooperative. Footnote 2. Spencer and his wife were both concerned that the person who contacted police had lied to them, as they knew she was not a mandatory reporter. They were not told that she had spoken to a third party who is a mandatory reporter or any of the other context of that conversation. They believed she had previously misled them about their child and had concealed the child's victimization at the hands of Fosler, her boyfriend. It was her boyfriend. They were upset because it seemed, with the information they had at the time, that she was again deflecting from Fosler's actions by accusing someone in the Spencer family of wrongdoing. It is difficult to imagine many fathers not feeling and behaving the same way when presented with such horrific and shocking circumstances. What Spencer said then and believes still is that a parent has an absolute right to defend their child against someone who is presenting an imminent danger of harm, like manipulating a minor victim to have S with him while awaiting trial for numerous S crimes against her when the judicial system cannot or will not protect them. And what matters is what actually happened, not what the state tries to piece together from picking and choosing words spoken months before the events that put the child directly within the control of her rapist. What really happened is that Spencer stood down. He did not attack Fosler when he confirmed his contact information. He went back home to talk to his family. Before they could do so, while preparing their child for the process of reporting this that she was about to go through, the officers showed up unexpectedly. The next day, they delivered their child for a forensic interview and allowed the criminal process to play out. They did interviews, delivered and consented to searches of electronics, provided witness information, etc. Fosler was arrested 4 days after that initial meeting at the Spencer's residence. He was seen by a judge the following day, and it seems an order out of the circuit court was entered imposing a mere $50,000 bond and generic no contact order prohibiting Fosler's contact with any minor. It was not specific to the Spencer's child and did not include any restriction concerning their property or other places the child may be present. Oh, isn't that interesting? It was not a specific stay away order against the girl or their family, just a generic one, or their home. Despite the plentiful evidence confirming the use of social media platforms to commit the offenses, he was not restricted in his use of social media. He was not required to report to anyone associated with the court or law enforcement. And neither his internet usage or physical movement were monitored in any way. The state's response then begins to describe the early morning of October 8th, 2024, as if Spencer planned this night of his daughter being SA'd by a 67-year-old man in order to efficiently and effectively take the law into his own hands. Such insinuation is offensive and absurd and once again favors the pedo instead of the victim. The state's own probable cause affidavit for the arrest of Aaron Spencer contradicts much its description of the morning Fosler died and certainly omits significant information about the events that led to Fosler's death. See affidavit for warrant of arrest attached as Exhibit A. We will look at that after this. That affidavit states that Spencer told officers, so this is the arrest warrant, because, they just let Fosler out, but, now they're going to charge Spencer. The affidavit states that Spencer told officers he had been woken up by his dog barking, which was uncommon, and went to check on his daughter due the events, and this is SIC, due to the events that had occurred earlier in the year. Aaron Spencer stated that the dog was in his daughter's bedroom, and when he opened the door, the dog continued to act out of character. Aaron Spencer further explained that when he looked closer at what he thought was his daughter in bed, he realized that it was actually a stuffed animal with his daughter's hoodie on it. Aaron Spencer stated that he became scared of what had happened to his daughter and had his wife call 911 to report her missing. Aaron Spencer then stated that he left his residence and began to search for Michael Fosler and his daughter. Aaron stated that when he arrived at the intersection of Highway 236 East and Highway 31 North, he observed the white Ford F-150 belonging to Michael Fosler turn off of Highway 31 North onto Highway 236 East, heading towards his residence. Aaron Spencer then stated that he turned around, attempted to stop the vehicle by flashing his lights and blowing his vehicle's horn. Aaron Spencer stated that he was in fear for his daughter's life and continued to pursue Michael Fosler east on Highway 236 East. Aaron Spencer explained that when they arrived at the intersection of Highway 236 East and Highway 13 North, he hit Michael Fosler's vehicle in the rear, causing it to slide off the roadway. Aaron Spencer then stated that he exited his vehicle with his firearm in hand and ordered Michael Fosler out of his vehicle and to lay down in the ditch. Aaron Spencer stated that he observed his daughter trying to exit the passenger side of the vehicle, but it appeared that Michael Fosler had grabbed her and stopped her from getting out. Aaron Spencer then stated that Michael Fosler exited his vehicle and had something in his hand, but did not know what it was. Aaron Spencer stated that Michael Fosler then lunged towards him, saying, "F you." Aaron Spencer stated that he then opened fire on Michael Fosler, emptying his weapon before jumping on top of him and pistol whipping him. Aaron Spencer then stated that he got his daughter out of the vehicle and returned to his truck, where he reloaded his weapon and called 911. All of that is in the arrest warrant. Spencer certainly never told officers he thought Fosler had entered their home and forced the child into his truck. But when Heather and Aaron Spencer found their daughter's bed empty, they were worried given what she had recently been through. They decided Heather would call 911 and he would begin searching for her in the area. They learned about that time from a family member. That Fosler had recently contacted the child, and then they were understandably panicked. They were terrified that Fosler would not only SA their child, but that he would kill her or disappear with her, knowing that she was the critical witness to crimes that would put him in prison for the rest of his life. Like any normal father, Spencer left his wife to stay on the 911 call while he went out searching for her. Contrary to the state's suggestions, there is absolutely nothing about him doing this that is unlawful or wrong. In fact, it is exactly what most anyone would do. So it seems that after they found out, after they saw her bed stuffed to make it look like she was still in it, they found out from perhaps this woman Higginbotham that Fosler had recently been in touch with her. I think they probably thought that their daughter had not been contacted by Fosler because, stay away order and everything else. But then they learned the most horrific thing that any parent could learn. Wow. Contrary to the state's misrepresentation, in his interview after the shooting, Spencer did not say he was vigilant for Fosler that night. Instead, he explained that he learned what Fosler looked like, where he lived, and what vehicle he drove because he was aware that no one was monitoring Fosler. And while he did not watch Fosler, he needed to know if Fosler was nearby. He was worried that without any real barriers in place, Fosler would seek the child out and hurt her again. He explained that he thought he had seen Fosler driving near Spencer's home several times, but he was not certain if it was Fosler, and if it was, Spencer would not confront him and instead would let the police do their job. But he remained aware of Fosler and aware that no one was watching him. So, as he explained to investigators, Spencer stayed vigilant for Fosler if he came near their home. Spencer said nothing to investigators about immediately getting in his truck that night to look for Fosler because he was vigilant for him. He was, however, vigilant in his desire to find his daughter. While Spencer was looking for his daughter, he happened to pass Fosler's truck as it turned onto Highway 31, several miles from where the Spencer's residence is located on that roadway. And Spencer saw his child in Fosler's truck. Spencer turned around to follow, and for miles, Spencer honked and flashed his lights, but Fosler sped up, fleeing with the child towards an intersection that would take them out of the area. Before that could happen, Spencer, having been trained in military tactics and maneuvers for disabling vehicles while avoiding significant injuries, pushed Fosler's truck into a driveway. Well, there you go. Is that a pit maneuver? Fosler exited the truck, coming towards Spencer aggressively with something in his hand, and Spencer shot him, unloading his clip. Fosler jumped into the ditch and continued to move and curse, and concerned that he may have had a weapon, Spencer hit Fosler with the gun to abate any further threat. The state suggests that Spencer had other options that night, including that he could have called 911 when he found Fosler with his daughter. This kind of hindsight is inappropriate and irrelevant. First, and most importantly, there is no law whatsoever in the state of Arkansas that requires any citizen to call 911 in the face of imminent danger. Arkansas law provides every citizen the right to protect themselves and their family from threat of harm. There is no condition to call 911 first and see if that works out. Second, Heather Spencer had already called 911, and Spencer knew that unless the sheriff's officers were ignoring the call, they were on their way. If it takes a second 911 call to make officers move faster when a child victim/witness in a pending Y felony case is missing, that is a significant problem for the community. Third, the state's representations about Spencer's phone are simply wrong. Spencer explained to investigators that he could not get his phone unlocked while driving, and also that when he was going so fast, he didn't want to have a wreck making a call. Not that he was driving so fast that he couldn't unlock his phone. The phone records confirm that this is true. He makes no call between the time he located Fosler and the shooting. He spoke with a family member before finding Fosler with his daughter. And while a family member sent him text messages during the interim time, forensic examination does not establish that he saw those messages at the times she sent them. A critical review of the phone data proves that the times correspond to when a text is sent and received and do not reflect an action to use the phone to read the message. Once he saved his daughter, his first and only call was to let his wife know that she was safe. Although he did not reach her, his next call was to 911. Samantha Smith is right. The rapist should have been behind bars. And we saw this happen again with the same exact judge in the same exact county with another kid who was 19, raped a child, and then got arrested, as I told you, in a different county because she let him out. And I can't even believe that Judge Barbara Elmore is still assigned to this case, as far as I know. She's the one who let Fosler out, and she's the one that's going to try Aaron Spencer. Make it make sense. I think there's only 2 judges in the building, but this is exactly the time when a change of judge is necessary. So said the Arkansas Supreme Court, in fact, when the gag order was taken up to the Supreme Court of Arkansas and overturned. Let me just put you on hold for 1 second while I take a call from a child. Talk amongst yourselves. And we're back. The state's assertion that Spencer had good reason to believe his daughter had snuck out of the house and had not actually been kidnapped that night is outrageous. It is as if the state is portraying this relationship between a child SA victim and her abuser as typical and consensual. The idea that a parent in this situation would reasonably believe that their child was safe in this circumstance is preposterous. Whether or not she was forcibly removed from her home, Spencer and any parent in that circumstance had good reason to believe the child was in danger. This is especially true here, where the rapist with control over the child is facing life in prison and the child is the sole witness. Even though it matters not how you label it, most reasonable parents would believe this was kidnapping too. Footnote 3, which reads, the defense believes Fosler did legally kidnap the child and does not concede otherwise. However, it is irrelevant whether his conduct technically met the legal definition of kidnapping. The comments also demonstrate a reprehensible blame the victim mentality. The state seems not to understand the victimization of children by pedos like Fosler. The child was 13 years old when Fosler began to groom and assault her, turning 14 years old shortly before he was arrested in July of 2024. Footnote 4, after groom says, grooming is behavior that manipulates and controls the child, as well as those around the child, to perpetrate the SA of the child. Among many other things, oh boy, this is going to get worse and worse and worse. This is the cold read. I didn't read this part of it yet, so I'm going to trigger warn you right now. Among many other things, he told her often how much he loved her and manipulated her into believing him and believing that she loved him, even when he hurt her. Unfazed by the dozens of S crimes he faced for his assaults against her and a no contact order prohibiting him from contacting a minor, Fosler continued the pattern of grooming the child so that he could maintain his ability to control her and to S-type violate her until the very end. Until the very end. Neither the Spencers nor any reasonable parent would ever consider their circumstances as just a teenager who snuck out of the house. I'm going to say it. I'm going to say it. Judge Barbara Elmore is 100% responsible for everything that happened here. For the continued SA by Fosler of Spencer's daughter, for Fosler's death, all of it. And you know who's getting a life sentence out of this? The little girl. The little girl is getting a life sentence. Fosler got to escape because he's dead. I've done a lot of work in my 30-plus year career representing victims and survivors of child SA and clergy SA as children. And when I represented many of them, they were full-grown adults. Full-grown adults who had never told anyone what happened to them when they were little, and now they were in their 40s, 50s, 60s. Pick a decade. And every child who is subjected to something horrific like this has a life sentence. They just do. Outrageous. It's outrageous. The state's behavior is outrageous, as if a 13-year-old, 14-year-old can consent to something like this. This is textbook grooming, folks. Textbook grooming. A 67-year-old man convincing a 13-year-old daughter, a 13-year-old girl, that he's in love with her and she's in love with him. Textbook. And I know, because of all of the work that I've done in this area, that the statistics show that a pedo is not caught until they have offended at least 100 times. How many other victims are there of Fosler? This is outrageous. And if the people of Lonoke County are not out there screaming that Judge Elmore should be removed from the bench because it just happened again. I don't know who should be screaming. Wow. I mean, in this filing alone, we are learning so much more about what happened here. And as if it could be any worse, it is 100 times worse than I even imagined. There are no words for this. The state also seems to be arguing that Fosler did not commit any crime in persuading his 14-year-old victim to leave the house so that he could pick her up and at a minimum have relations with her. But Fosler committed multiple felonies against the child that night. Oh no. Oh no. So he did commit more acts against her that night before she was saved by her father. Every parent's worst nightmare. So apparently, he did commit multiple felonies against their daughter that night. Yet, the state seems to insinuate that Fosler did not, in fact, present a danger to his child victim on the night of October 8th of 2024, an insinuation that is so flabbergasting, it is difficult to comprehend. The state does not, however, offer the last piece of its theory that since the state says Spencer really believed the child willingly joined her rapist that night, he should have called police a second time rather than follow Fosler and just secure this child's safety. The state does not explain how Arkansas law requires any person to refrain from acting in favor of hoping for a police rescue in the face of such danger. The state likewise does not explain how its proposed plan of action would have assured the child's safety. The state does not explain how Arkansas law required Spencer to choose to let Fosler flee with his daughter instead of intervening to protect her. Nothing that Spencer said months prior has any bearing on these issues. The only facts that matter are those that put a child victim under the sole control of the pedo who had repeatedly harmed her. Spencer's anger months prior in no way changes the scenario Fosler created that night. Whether Fosler forcibly kidnapped Spencer's 14-year-old daughter or groomed her so that he could continue to abuse her, if not disappear her, the analysis is the same. Either scenario created a legal duty and a legal justification, and certainly reasonable cause for Spencer to act to protect his child from a predator who refused to leave her alone and who presented a real threat to her safety, both as a victim and witness to his crimes. The suggestion that if Spencer thought his 14-year-old child may have gone willingly with her rapist, Arkansas law requires him to sit back and hope for the best is outrageous. But this is apparently the core issue in this case. Thus, it matters not what Spencer felt or said months prior when he learned of Fosler's grooming and abuse of his child, because on the morning of October 8th, 2024, Fosler, by his own choice, posed an imminent threat of harm to his victim, and Spencer had every right and indeed obligation to fight to save her. Praise be. Praise be. Under her eye. It feels like we're in The Handmaid's Tale. Roman 2, next argument. This is not proper 404B evidence. The issue for trial is not whether Spencer killed Fosler or whether he intended to kill him or planned to kill him or knowingly killed him. Thus, the 404B analysis does not apply. The issue is whether at the time of Spencer's action, he had reasonable cause to believe that Fosler was committing or about to commit a felony involving physical force or violence, or was using or about to use unlawful deadly physical force, and or whether Spencer's conduct was necessary as an emergency measure to avoid imminent injury where, according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent injury to his daughter and or himself outweighed the injury to Fosler. These are complete defenses. The state has to prove otherwise beyond a reasonable doubt in order to convict Spencer. So you see the burden of proof shifts back to the Commonwealth to prove beyond a reasonable doubt that this is not what happened. So they have to disprove self-defense and justification. Woman of Steel says Aaron Spencer is a hero. Spencer did not, as the state insinuates, stalk Fosler and kill him. Spencer did not allow Fosler to kidnap his daughter and grape her so that Spencer could kill him. Those suggestions are absurd. Fosler made the choice to violate the law and the court's order and to once again endanger his child victim. In fact, he was unrelenting in this regard. Fosler created and presented a real danger on the morning of October 8th of 2024, not Spencer. And therefore, Spencer's initial reaction months prior has no relevance to Spencer's necessary use of force months later. Unless the state is planning to present a theory that Spencer set Fosler up to take his child and assault her on the morning of October 8th, 2024, so that he could kill Fosler, there is no legitimate 404B issue. The issue for trial is simply whether Spencer manifested extreme indifference to the value of human life or whether he may have had reasonable cause to fear for her safety at the time he acted to present his child. Whether Spencer also hated Fosler or was angry at him after finding out about Fosler's horrific crimes does not impact this analysis. If he had reasonable cause to believe that Fosler posed an imminent threat to his child, he's not guilty. Whether or not months prior, Spencer had said things in anger about not wanting police assistance or thinking that it's BS to suggest a person could not protect another person from harm without going to prison, the issue for the jury is whether Fosler's actions created reasonable cause for Spencer to act in fear for his child's safety on October 8th of 2024. Allowing the state to taint the jury with emotional reactions untethered temporally, meaning untethered in time, to the events of October 8th, 2024 violates Rule 404. Cami says, all because of a judge's neglect to protect. Right. Roman 3, the state ignores Arkansas Rule of Evidence 403. The state completely ignores Rule 403 in its response. Even if relevant under 404B, the evidence still may be excluded under 403 if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury. That is precisely the purpose and effect of the evidence at issue. And I agree with the defense on this argument. Nothing about Spencer's comments in July 2024 shed light on his actions or Fosler's actions on October 8th, 2024. Even in July of 2024, Spencer did not act upon his frustration or anger. He tried to identify Fosler's residence and his vehicle, and he went home. He thereafter consented to searches and cooperated with investigators. He was, as any parent would be, diligent in trying to keep his daughter safe from Fosler, getting her therapy, limiting her contacts, homeschooling her, etc., and beginning to understand her suffering from the mental manipulation of this man. He was, as any parent would be, diligent in learning information to identify the person who targeted and hurt his child so that his family would be aware if this man targeted her again. It was only when Fosler actually took his daughter from his home that Fosler presented an imminent danger to her that justified Spencer's actions to protect his daughter. As it turns out, unbeknownst to the Spencers, Fosler had been communicating with the child since about a month after his release on bond. Wow, he just didn't quit. With no bond condition or supervision dissuading him, he continued engaging with her and others on social media platforms and had directed the child as to keeping the communication secret. He had picked her up on 3 occasions between his release from custody and the night of October 7th, 2024, without anybody knowing. Wow. Just wow. Judge Barbara Elmore enabled this girl, this little 13-year-old girl, to be raped and other things numerous times. Beginning 1 month after she let him out with $5,000 cash, do not pass go. And others. He was also communicating with others. Are there other victims? Are there other children out there who were victimized by this dead man? Who was a police chief in Hamlet, Indiana years before? On this final occasion, Fosler spent about 4 days or so persuading her to leave her house and go with him for the express purpose of committing criminal acts with her. She left the house around midnight, and Fosler picked her up near the Spencer home. Fosler then drove her to his home in Cabot, Arkansas, SA'd her, and was driving her back near her home when Spencer encountered them. It was too late. Spencer had no idea that Fosler had continued to communicate with his child after the arrest, and he certainly had no idea that he continued to victimize her. Hold on. Like any parent, Spencer went looking for his daughter when she was found to be missing. Once he saw Fosler with her in his custody, Fosler made clear he would not peacefully let her go. Like any parent in that moment, whether or not a 14-year-old child recognized the danger, her parents believed that she was in danger in the custody of her rapist and that Fosler had every reason to harm her to avoid life in prison. Fosler certainly did not, by his own behavior that night, indicate otherwise. To permit the state to try this as a case of premeditation or intentional murder, as if there is no legitimate question as to the risk posed to the child victim that night, or as if Spencer somehow knew and planned to kill Fosler and allowed Fosler to harm his daughter again to do it, would be prejudicial error, allowing the state to try Spencer for his reaction to the initial disclosure of abuse and the gory details, and not on the circumstances and actions that led to Fosler's death. There's absolutely no evidence to suggest that Spencer knew Fosler would take control of the child and create a situation in which Spencer had to defend her, and to allow the state to suggest so is highly prejudicial and misleading. Spencer's comments in July are irrelevant to the issues in the case and threaten to confuse the issues for the jury's consideration and mislead them into a fundamental misunderstanding of the law and how the facts apply to it. Conclusion. Allowing the state to suggest that Spencer's actions to protect his child from her rapist were not motivated by concern for her safety at all, but instead by the panic, anger, fear, or frustration he expressed 3 months earlier would be prejudicial error. His comments upon learning that his child had been sexually abused do not make it more or less likely that he reasonably believed she faced danger when Fosler had her in his control and refused to release her. Any suggestion that those comments demonstrated intention or plan to act months later, when Fosler actually had control of his child for purpose of engaging in criminal acts, is illogical, unsupported by the circumstances, and would mislead the jury. Coco says Fosler's record is sealed and there are tons of victims. Or I said this says there are a lot of victims going back decades. The events of October 8th, 2024, Fosler's actions and Spencer's response to them are the relevant facts the jury must consider. The state should not be permitted to divert attention from those facts by implying that Spencer responded poorly or displayed bad character when he first learned of his daughter's victimization. Spencer did nothing to harm Fosler at that time, and instead he and his family cooperated with authorities prosecuting Fosler. It was not until Fosler put Spencer's child in danger again that Spencer acted to protect her. There was nothing vigilante about Spencer's actions to protect his child on October 8th, 2024. he acted in response to an obvious threat of harm. Although the state apparently disagrees with Spencer as to whether Arkansas law protects a person from prosecution for protecting himself or his family when confronted with imminent danger that is uncontrolled by law enforcement or the judicial system, that decision is for the jury. Wherefore, the defendant, Aaron Spencer, asks this court to grant the defendant's motion in limine and for any other relief the court finds appropriate. Aaron Casanelli, Michael Kaiser, Lassiter, and Casanelli out of Little Rock, Arkansas. Here, as Exhibit A, is the arrest warrant of Aaron Spencer. I'd like to see the arrest warrant for Michael Fosler, but that's locked up like Fort Knox and sealed. And so here is the arrest warrant. Facts constituting reasonable cause. And this is dated October 8th, 2024. In the Circuit Court of Lonoke County, Arkansas, affidavit for warrant of arrest for the following person, Aaron David Spencer. Pursuant to Rule 7.1 of the Arkansas Rules of Criminal Procedure, undersigned affiant being duly sworn deposes and says that he has reason to believe that the above-named person has committed the offense of violating Arkansas Code Annotated 510-102, murder in the first degree, in Lonoke County, Arkansas, against the peace and dignity of the state. Facts constituting reasonable cause. On October 8th, 2024, at approximately 01:13 hours, deputies responded to a call on Highway 236 East in reference to a missing juvenile. Deputies were advised that the missing female juvenile had been graped and essayed by a Michael Fosler in July of 2024, and that he was known to drive a white Ford F-150. Lonoke County Dispatch requested that Cabot Police Department send officers to blank within their city to try and locate the missing juvenile at Michael Fosler's residence. Prior to receiving information from Cabot, dispatch received a second call from the father of juvenile, identified as Aaron Spencer, stating that he had located the man who kidnapped his daughter, Michael Fosler, and his daughter, but that the male was dead on the side of the road and that he had no choice. Deputies arrived at blank inside the rural area of Lonoke County and located both Aaron Spencer and Michael Fosler. Deputies immediately began life-saving measures on Michael Fosler, but he had succumbed to his injuries. Deputies took Aaron Spencer into custody and secured the female juvenile away from the scene. Deputies cleared and stored the weapon, a Glock 19 Gen 4, that was found to have been on the person of Aaron Spencer and had blood on the outside of the weapon. Detective R. McCain, was the first detective on scene. Upon arrival, I observed a Ford F-350 sitting north of the scene, angled in the northbound side of Highway 13, with a white Ford F-150 sitting next to a driveway. The white Ford F-150 appeared to have been forced off the roadway due to skid marks located on both the asphalt surface of the highway and through the ditch line. Michael Fosler was lying on his back in the ditch on the east side of Highway 13. Michael Fosler had visible puncture wounds believed to be caused by a firearm projectile on his chest, abdomen, and both left and right arms. Upon inspection of the white Ford F-150, damage was located on the rear of the vehicle, normally seen after impact with another object. An examination of the Ford F-350, now it's an F-350, showed that the vehicle had damage to the front and commonly seen after impact with another object. Wait, so somebody had an F-350? Okay. All right, so maybe the white Ford F-150 was Fosler's car and Spencer was driving a Ford F-350. Okay. So an examination of the Ford F-350 showed that the vehicle had damage to the front end commonly seen after impact with another object. The search of the area was performed. During the search of the area, several spent 9mm casings were located on the roadway, driveway, and ditch area surrounding the white Ford F-150. From what I'm reading here, it seems that Aaron Spencer stayed at the scene. Weren't we led to believe that Aaron Spencer, like, pumped him full of lead and split? But from what I'm reading here, it seems like he stayed at the scene. I don't know. Unclear. But both cars were there. Aaron Spencer was there. I mean, he says, I was the first detective on scene. Upon arrival, I saw the Ford F-350 and a white Ford F-150. His car was still there. Did he run away with his daughter? I mean, it seems like he stayed. They shut down all the information on this case that started. I know, it's all sealed. I'm glad this is an exhibit because we never otherwise would have seen this. Once clearing the scene, myself and Detective N. Rice interviewed Aaron Spencer at the Lonoke County Sheriff's Office after being advised of his rights, to which he acknowledged understanding in reference to the events that had occurred. Aaron Spencer stated that he had been woken up by his dog barking, which was uncommon, and went to check on his daughter. And we read all of this before, and the bed was stuffed. And the rest of this, I believe, was in the body of the responsive pleading that we just read. And then it says, I swear that the allegations contained herein are the truth to the best of my knowledge and belief. Signed, Deputy Sheriff, October 8th, 2024. All right, let's go to the chat. You just, I mean, really victim blaming a 13/14-year-old girl who was clearly groomed by a 67-year-old pig monster. Ink Smelly Music says, 13 whole months. I wrote a song about all this corruption, Curtain Call by Chastity Danielle. If anyone wants to check it out later. Thanks, Chastity Danielle. Where can they find it? Is it on YouTube? Thanks for being with me for 13 months. You're awesome. On top says, this guy's a national hero. One man's opinion. I don't think you're alone in feeling that way. Brass 6073 says, who the F is Fosler connected to in Arkansas politics? Well, he was the chief of police in Hamlet, Indiana, many years prior, so I don't know. I don't know. There's a lot of locals in the chat. Maybe they know. Pig and Monster is too kind, I know. Some guy with cancer. Thanks for your FI. I'm sorry about your cancer. It says the judge didn't order any type of monitoring on Fosler. The 19-year-old was arrested in Pope, I think you said. Yes. I think it was Polk, right? Which is another county in Arkansas, right? Oh, it's Pope County? Did I say Polk County? Pope County? Yes, that is correct. He was arrested in another county, and he's being held on $500,000, I believe, bond, and I don't think he's going to get out. Do you? People in the chat saying that pedos cannot be rehabilitated. I happen to agree with you. I happen to agree with you. All right. Thoughts, questions, comments, concerns before we wrap and thank the mods for this long stretch. I got to go do some mommy things. Got to go do some mommy things. Oh, yeah. One other thing that popped up in the docket on Karen Reed is that there's a guy, there's been an affidavit of service or something filed in the Karen Reed's new civil case, Karen Reed against Proctor and everybody else, that there's an attorney by the name of Timothy Burke who has agreed to accept service for Brian Tully. And this attorney, Timothy Burke, is a criminal defense attorney. He also does a lot of work for police who are wrongfully terminated and such as like that, because I looked them up. So in case you're wondering about that, there's the deets on that. Oh my God. So Diane says, I just looked to see if Hamlet, Indiana has an explorers program. And Diane, and when we looked up the explorers program, when we first started covering Sandra Birchmore, we learned that there were like 200 other claims against the police explorers programs nationwide for other children who were abused by the police explorers people, chiefs, whatever the F they call themselves. All right. I don't know what's going to happen. All right. So the next thing to happen on Aaron Spencer is going to be, is supposed to be the pretrial hearing on December 17th, which if you can get into it would probably be a good thing to go to, because it is likely where these motions in Limine will be argued. And there will probably be some more filed before that. I think the deadline for all filings is coming up. So in the coming days, we may have a bunch more motions to go over on the Spencer trial. And then Aaron Spencer's trial is supposed to commence January 26th. And it's supposed to be a 5-day trial through January 30th in Lonoke County, Arkansas. So if you are boots on the ground in Lonoke County, Arkansas, let us know if you're going. Let us know in the comments. Thank you to the moderators for keeping it classy today. As always, my streams are difficult to cover because, a lot of people hate me and want to troll me. But whatever. John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. Cry about it. Stay cool, stay kind, stay classy, my friends. I know you can. I know you absolutely can. With regard to the rest of the world, just stay safe out there, you guys, because it's dangerous. I'm sure I'll see you tomorrow. So make sure you have all your notifications set. Make sure you have them enabled on your phone. Make sure you're still subscribed. And I love you all with all of my heart. And I am so grateful that you choose to spend 3 hours of your day with me today, this Monday, November 24th. Peace out, you guys. I'm sure I'll see you tomorrow. Who knows what we'll talk about, because lots of things may pop up before then. Peace.